nice to have young people here. Roll call?
Sure. Thank you. Second?
Signing is open.
So meeting of the Board of Registrars calling to order, calling the roll call of attendance. Board member Aldonza Pereira.
Present.
Pereira.
Pereira.
Pereira, thank you. Sorry about it.
I see it.
City Attorney Body, present.
Present.
Council Chair Petrakis.
Present.
Council Chair, Mr. Chairman, and Board Member City Clerk William Maloney, present, all present. All set.
Now rise for the Pledge of Allegiance. Pledge of Allegiance.
One nation, under God, indivisible, with liberty and justice for all.
All right. So we're going to open this evening, and we're going to hear from Mr. Reyes from the Elections Office regarding a report, a summary of voters signing recall documents that were submitted. Mr. Reyes?
On September 2nd, 2015, Attorney Louis Farah, on behalf of the Foundation for Transparency in Government, filed 181 documents with the Office of the City Clerk. Entitled Recall Petition Affidavit, Section 927B of the Lawrence City Charter. In support of the recall of Mayor Daniel Rivera, with information contained on the front and back of each 11 by 17 document. All 181 documents, date, stamp, initial, and mark each page, effectively as page 1A, 1B, 2A, 2B, and continuing to pages 181A and 181B. The City Clerk immediately forward all signatures appearing on the document submitted to be reviewed by Senior Accounting Clerk, myself, Richard Reyes, to determine the voter status of each individual signing the document. On Thursday, September 3rd, 2015, Senior Accounting Clerk, myself, Mr. Reyes, submitted the following report to the City Clerk Maloney in regard to the 181 signatures submitted as described above. 136 signatures of registered voters to be certified, 44 no such registered voters at the address or address was ineligible, and one unable to identify signatures of that voter because a form of signature or signature is ineligible. Total of 181.
Thank you.
Mr. Chair, through you, given the nature of the proceedings, first of all, I want to welcome both counsel to both sides, Attorney Tabit, Attorney Newman, Attorney Farah. How I'd like to proceed, if it's all right with the chair, is to ask, first of all, for a couple of preliminary matters before proceeding, and to have the city attorney address the public, ourselves, and the parties, how the proceedings will take place and what we can expect. And then to open it to questions from the board members as to any questions or initial inquiry that we may have regarding the proceedings, which could either dispel many of the issues that are present before us or complicate matters even more, hopefully not. And I'll then turn over to the city attorney Body for that reason. Attorney Body?
I'm sorry, specifically you're asking me how we proceed, is that the?
Yeah, I think just for the edification of the board and the public to just outline a brief process, parties to address, opening statements, evidence to be adduced, things of that nature, in a shorthand fashion, if you could.
I think I covered most of the information the last time we met, specifically with respect to advising council as to what our expectations were. As you know, the standard for us is evidence that a reasonable person would rely upon in making serious decisions. And I think that there's certainly no harm if the parties require, there's no harm in allowing either side or both sides to make an opening statement. I don't think it's necessarily required. Certainly, counsel for Mayor Rivera filed a several-page document entitled Objection to Affidavits Pursuant to Mass General Laws, Chapter 55B, Section 7. That document breaks down in 47 paragraphs and into several different categories the objections that are being made specifically to particular affidavits. Some affidavits, there are multiple objections made to them. I think that, far be it for me to advise people how to proceed. I think that's up to attorneys Tabit and Newman, but I think obviously since they filed the objections, the burden is on them at this point in substantiating their objections and having the matter proceed. So, as I would see it, if any party wishes to make an opening statement, I think that's fine. I think that perhaps for matter of clarity of the record, at some point, whether that's done initially on each objection or at the end, vote should be taken objection by objection.
Certainly agreeing with all of what you said. If I could comment, Mr. Chair, through you. I would ask that for permission to inquire about a couple of matters of concern to the board first, and then proceed to opening statements. In terms of the proceedings, unless either side has witnesses to be sworn, I don't see any reason to swear in counsel on your oath, certainly as attorneys. The same standard, the judicial standard would apply. I would ask the city attorney directly, number one, what is the status of the appeal before the appeals court and/or stay in Superior Court? That would be the first question, so that we can proceed.
Nothing has yet been filed in the appeals court. The matter is still under research and discussion internally. With respect to the matter before the Superior Court, it was heard by a judge who is sitting at Lawrence, who is now sitting in Boston. A motion for stay of proceeding was filed, along with a motion for reconsideration. As of yesterday, an assent to the motion for stay was filed by the attorneys who represent Mayor Rivera. There has been no action on any of the pending motions before the court yet. And so as a result of that, I think it's incumbent upon us to proceed.
In light of that, I don't know if you can answer this question or not. If the board, and the board is certainly here to proceed, would that prejudice the board in any way, or prejudice the city of Lawrence through this board in its action to stay proceedings and/or to appeal, in your estimation?
I don't think it would prejudice us. Again, remember, we are under an order to conduct the hearing. I think we have a right to appeal that order if the appeal is made in a timely fashion. So I don't think it compromises any position on either side.
Thank you. I think I'm satisfied with the two questions I have. Is there any issues?
I have no other questions.
Any other questions for the chair? Shall we?
Yes?
If the parties would step forward, I guess at the indulgence of what the city attorney suggests, since the moving party is here and the opposing party to the moving party is here, shall we proceed to opening arguments, or an opening statement, we'll say, rather than opening arguments?
That's fair. Yeah, we
Please use
have,
the microphone.
we have a recommendation. It's Dennis's recommendation. I'm sorry, Mr. Newman's recommendation. He wants to present his objection category by category, and he'll give me an opportunity to rebut it. So I guess we'll start by the categories first.
So as we understand that neither side wishes to make an opening statement at all, and then we'll go right into the, want to go right into the objections?
No, we want to have opening statements.
Oh,
but-
okay.
But we want to take category by category for objections.
And not necessarily in the order of the categories, probably more in reverse order, but rather than go through everything and have a rebuttal.
30 or 40 categories, or?
Well, there's more like 6 or 7 categories, actually, because the categories have multiple ones within it.
Go to it.
begin with-
May I just ask
Your show.
a question in terms of formality? Are you the one who's going to be presenting the objections on behalf of the mayor?
I will be presenting many of them, and my brother will be presenting some of them also.
Okay.
But we won't, it'll be either or for the category, so.
Thank you.
Just for
begin-
the sake of the record, all councilors filed an appearance timely.
What I'd like to do, in terms of exhibits, if you will, is give to the board a chalk, if I may approach. If I can describe the chalk, what it is, it's all of the objections in numerical order. I'm sorry, all of the affidavits that we object to in numerical order, and then the status, whether they're inactive or active. If it's blank, they're active. Whether or not it was counted as one of the ones, and then the 10 grounds. And then the last column is board action, so that as we go through the objections, this is a scorecard that you can use to kind of keeping track of the objections and what the decisions are. If it's, I think it might make it a little bit easier to follow, if that makes sense.
Well, just so the board knows, I have provided the board with the similar tally sheet.
Okay.
I intend to use and follow through. This is a great reference, certainly. I don't think Mr. Farrell would object to using either, just as a reference. Have you seen this?
Yeah, I've just gotten a highlighted one now.
Yeah, me too.
Right. I would object that we go line by line. I would rather go category by category.
I agree.
Because our defenses are gonna be simply that there is, and I will get to that in a minute without taking time from Mr. Newman. Our defenses are gonna be that there is no standard by which these objections can be raised. If we do it category by category, it may be helpful.
I'll leave it, and through the chair, I'd leave it up to you guys as to how do you want to proceed. That's certainly, it's your case, counsel, on.
Yes, and I agree. I think we agree on that.
And I, again, we're here to be educated, I guess.
The other thing I'd like to put into evidence is a thumb drive. This is the source material for the information on active or inactive and some of the other things that we're going to do. It's the voter file as of July 15th, which we received from the city. Thank you.
Unfortunately, we don't have anything to open or read a thumb drive with, so I'm gonna suggest that you hold on to this and make specific reference to statute references, CMR references, or any other treatise. Without the ability to look at it and see what it is, I see this of no value whatsoever.
Well, I think this is, I'm not suggesting that you look at it during the deliberations here, but if there's deliberations after, I think that when you go to look at other material, when you do research, I just want to have, that we didn't make this stuff up, that it actually came from that source.
Again, my understanding is that this is a quasi-judicial proceeding. I'm not suggesting that this is a non-judicial manner in which to enter it, but typically what I'm used to getting is a hard copy of everything that's submitted and referenced.
Well, may I?
I would be happy to, provide you with a hard copy, but it's hundreds and hundreds of pages. I just thought this might be a little bit easier, that's all.
May I just, for my own clarification, I'm not sure I understand. We provided to you voter signature cards, and voter registration cards, and what you're returning to us is a copy on a thumb drive of what we gave to you?
No.
Okay, so explain to me, because I don't understand what is on that thumb drive, please.
There are, on the objections, on signatures and signatures that we question the genuineness of the signature, we will present evidence, which will be what you gave us in hard copy. For the chalk, where it has inactive, that's We got that from that voter file,
What voter file?
from the voter file on the disk.
This
That's
is
correct.
all the registered voters in the city.
Yes,
Is there anything else on here other than the registered voters list?
no.
Okay.
Oh, I see. I
Okay.
misunderstood.
Just my clarification,
Well-
that is a July 15th list. Is there a more recent list that has come out?
The list changes every day. Every single day.
Okay, so if I could, again, just, you're submitting a thumb drive of the voters list. The question has been raised as to what date is the date as current on the thumb drive. Do you know that?
July 15th.
Okay. And I guess, I mean, I understand what the clerk is raising as issues, but, I mean, one of the other things, perhaps, if I may, perhaps we need to find out whether there's any objection. Are there more exhibits that you're going to offer?
Yes.
Okay. So at some point, I think, you know, you need to find out whether there are whether there's an objection to our accepting that. I'm less concerned, with respect to, I'm less concerned about this. If this is the voter registration list, we can't open it, but that doesn't mean it can't be opened if we need it.
Well,
I'm not sure what the, again, I'm not sure what the relevance is, but if you want to submit the voter registration list as of July 15th.
What is the relevance?
That's the only point I raise as a board member is I have no idea what's in this list. I have no idea where it was derived from. I can take your certainly offer of proof and accept that. And certainly your offer of proof is that it's July 15th of 2015, the voting list. Again, I'm not looking to verify it. It's your statement, it's your offer.
So,
And we'll accept it de bene, I guess, is the best way to do it.
well, I don't know that I mean,
I don't know what's on it.
It's been offered and there's been an objection, but I don't know, again, let's set up a procedure, if we will. Are we going to entertain all the things that Attorney Newman wants to introduce to the board, and then make decisions as to what will be admitted based upon providing an opportunity for objection? Or are we going to do it piecemeal? If the case is we're going to do it piecemeal, then let's first start with the chalk, then move to the thumb drive. If we're going to
I agree.
let him make the offers of everything and then allow objections and then make decisions as to what will be accepted, that's fine too. But let's do this, if I may suggest, in a structured manner.
I agree with you, and what I'm suggesting is that there is no structure to offering it all here, take it all, and then,
So-
my understanding is that as evidence is adduced and commented upon, that is presented and offered, and an opportunity for objection from the other side is entertained.
Okay. So a chalk has been offered, but it's not offered as evidence.
No.
It's an
And
exhibit.
so it's offered for ease and convenience in terms of recording the board's action on all of the objections on the 181 or so affidavits that were filed.
Yes, and only the highlighted ones are the ones that we objected to, with the exception of the general category of inactive. Those are the only ones, the ones that are highlighted are the ones that we have objected to.
So I think before we get into the thumb drive, if I may suggest, maybe the chairman can have a discussion with the board and decide whether this is what they want to use, or you also have, I think, another recording device, and perhaps that's what we want to use. I don't know. I don't have a preference, but let's make the decision what we're going to do.
Well, Mr. Chair, if I could, what I'll do is comment, as I started to comment just on the chalk and limiting my comments only to the chalk. I think it should be taken as an exhibit in reference to the way Mr. Newman wants the board to see it. Because it was prepared by a party to the proceeding, that it be only taken as an exhibit and only used for whatever purpose the board individually or collectively deems it useful or necessary. We have the wherewithal and do have each one of the petitions marked and without the advocacy, if I may, of the yellow highlights and the X's and the O's and all that stuff, and I consider that advocacy. I'm not objecting to it, I don't. I think it's very helpful, but I think it is advocacy. And I think it'd be taken only for the limited purpose that it advocates, and that we resort to our own materials in terms of final decision-making, motions, paperwork, et cetera. And I make that in the form of a motion.
I second the motion.
Discussion. Any comment or discussion on any?
I'd rather use the one we have and use this one as a reference.
Thank you. We'll proceed with our own document.
Okay, and I'll call the motion, Mr. Chair. All in favor?
Aye.
Aye. 4-0, no need for roll call. Next. Proceed.
Oh, sorry. The first objection that,
Excuse me, can we just decide what we're doing with
Oh.
this? Respectfully.
I would open it again for discussion, if I may, Mr. Chair. I don't know what's in this, I don't know what's on it. I don't know what purpose it's being offered, or even if it's being offered as evidence. If you're asking us to take notice of a treatise or a document that is accumulated in the course of public record-keeping, I have no idea. I take your word for it that it's July 15th, but I have no purpose attendant to it. What I'd suggest, if you are offering it, that you offer it de bene.
offer, I'm sorry, what?
Offer it de bene, subject to connecting up.
Yep. Yes, please.
Is that,
I have no objection.
I'd make a motion as to that.
I'll second that motion.
De bene on the drive. All in favor?
Aye.
Aye.
Aye. Proceed.
Please proceed.
The first objection that we're going to cover is paragraph number 47.
Paragraph 47 in the objection.
The specific
mark that-
objections
can
are
we-
filed on Monday.
For purposes of clarity on the record, can we mark the objection that was filed as a joint exhibit? Attorney Farrar? It's okay?
Yes, yes.
Exhibit 2.
Okay. So what was Exhibit 1? I apologize.
Exhibit 1 was the grid.
Chuck?
Big chalk.
But we're not using it. So why is it,
It was marked in as an exhibit, it was voted to use it as exhibit in reference. That was the vote of the board, 4-0.
I thought okay.
The chalk was as an
I
exhibit.
thought we voted to
This.
accept this de bene.
De
but I
bene.
didn't think we,
You voted on it.
all right, I guess I was asleep.
Want to call it again, or you voted?
No,
All right.
that's fine. So.
Exhibit 2.
Exhibit 1 is the chalk.
Right. Exhibit 2,
Joint exhibit number 2.
joint exhibit, thank you. By agreement.
Now, is it Mayor's Exhibit 1? Is that what we're calling it?
Well, since it's a joint exhibit, why
Is
would...
Exhibit 1 a joint exhibit, Mr. Farrar?
You want to mark, just so I understand,
The chalk?
Oh, the chalk, excuse me.
chalk is going to be exhibit 1.
Is it going to be a joint exhibit, sir? Okay.
Sure.
Okay, so joint exhibit 1 and joint exhibit is the chalk. Joint exhibit 2 is the objection filed, if I may,
October 19th.
October 19th. Okay. Paragraph 47, you said? Attorney?
Yes. We believe that all the affidavits are invalid and that they do not meet the requirements for affidavits because they're not signed under the pains and penalties of perjury. The affidavit must have at least a statement containing that statement in order for it to be valid.
The statute with respect to affidavits, yes.
Just procedurally, and I don't mean any disrespect to you, but I think you've made your objection. Are you finished making your objection, Attorney Nolan? Yes. Okay. So you have a rebuttal to the objection?
I do, and I can deliver it before or afterwards, whatever your pleasure is.
I would suggest, Mr. Chairman, that we hear the objection, offer an opportunity for rebuttal.
Please.
And then how will we proceed? If I may, how will we proceed? Are we going to take a vote after that on whether to sustain or overrule the objection?
Well, we'll proceed with questions for either party, and then a vote.
Okay, thank you. I'm sorry for that. I'm just trying to make sure that we have a process that I understand.
The magic language under the statute for an affidavit is signed under the pains and penalties of perjury. It's stated twice in the affidavit. It's in the very first or second paragraph at the beginning. It's also under personal knowledge, information, and belief. So our position is that it's recited 2 times, and it comports with the requirements of the statute. Thank you.
Excuse me. That's a question.
Yes.
Does the statute define where in the affidavit
No.
this needs to be?
To my knowledge, it does not define where it is. I've practiced for a number of years, and I see them everywhere. Sometimes they're at the bottom, sometimes they're at the top, but the important piece is that but for a typographical error, it's recited twice. It's missing the words under.
Are you aware of any other formatting requirements or precedents under law regarding?
There are none others. This is, an affidavit is considered in-court testimony. It's one sworn statement, and it has the effect of penalty, as one would have maybe at this hearing as well as in a court. It does not require that it be notarized. It doesn't require that it be witnessed.
Does it require identification?
Absolutely not. It does not require identification.
I have no further questions for you. Do you have
Thank you.
any questions?
Attorney Newman, I think that the introductory paragraph of each of the documents submitted as affidavits by the recall group has language in it that says signed under the pains and penalties of perjury. And I understand the objection that has been made is to the last paragraph, which doesn't quite fit the bill. It doesn't quite say, it says signed and the pains and penalties of perjury, or something to that effect, not under the pains and penalties of perjury. But, okay, signed and the pains and penalties of perjury. However, the second introductory paragraph says, I, the undersigned registered voter in the city of Lawrence, hereby make this affidavit under the pains and penalties of perjury and upon my personal knowledge, information, and belief. The objection is based upon the fact that the documents aren't signed under the pains and penalties of perjury. How do you reconcile that first paragraph with your argument?
Where the signature is where the mistake was made, when it's not signed under the pains and penalties of perjury.
So is it your position, therefore, that the only thing that is signed under the pains and penalties, or the only time a document is signed under the pains and penalties of perjury is for what's immediately above that oath, and not anything else in the document?
Well, if you look at the document, the first paragraph or second paragraph, it's all the way on the other side, and then it's not signed under the pains and penalties of perjury. It's not right above the signature where the person is actually signing and putting their residential address.
If it were on the same side, would it, but at the top of the second page, would it make a difference?
It would be not clear, it would probably be less of a problem if it was there, it was at least on the same page, but I would submit that it has not met the qualifications for an affidavit.
Is the affidavit the entire document or a portion of the document?
Well, where it's signed is, the affidavit is the entire document, but where it's signed is where it should state that it's signed under the pains and penalties of perjury.
Does it matter that it's numbered? So it goes from one side to the next, and it's adequately numbered and then signed?
I'm not sure I understand.
What she, if I may, what she's saying is the document is a two-page document. Paragraphs as the grounds are listed numerically, and the numbering of them begin on the first page and flow through to the second page. So I think what she's suggesting is that does the numbering from one page to the next have an effect on the validity of that first introductory paragraph?
We do not believe so. Well, it's our position that it does not.
Does it for me.
Under the decision Galvin versus Town Clerk of Winchester, what were the circumstances? It was cited, what were the circumstances?
The Winchester Charter required that a recall affidavit in Winchester be commenced by the filing of an affidavit signed by
Yeah.
so many registered voters.
Galvin, I'm sorry.
Go ahead.
Galvin was a case where it was not signed under the pains and penalties of perjury and it wasn't notarized. So it was a clearer. Obviously, this is not as clear as that.
So as I was saying,
We just covered that.
in the charter in Winchester, it required that it be started by an affidavit. And as Mr. Newman said, the document that initiated the recall procedure was not signed under the pains and penalties of perjury, and it was not notarized. One or the other is required by Massachusetts law to be a valid affidavit. I think we can agree on that?
Yes.
Okay.
And our deviation is in the word "and" versus the word "under."
Yes.
Thank you.
Further rebuttal?
Is there further rebuttal? Is there further rebuttal? Does anyone else need to speak on the issue? We're ready to vote.
No, just that there is no statutory required placement of those magic words, and pains and penalties are clearly indicated at the signature line. That's it. Thank you.
I got one question, if I may, to Mr. Newman. Mr. Newman, what jurisdiction does this board have to even consider the validity of an affidavit?
I'm
Under
sorry.
what statute, constitutional provision, city charter provision, can you cite a provision that gives this board the
The
authority,
charter
the
requires that,
jurisdictional authority to consider the validity of the affidavit?
I'm sorry.
What gives this board the authority to, the jurisdiction to consider the validity of the affidavit in your estimation? Or under your...
City charter requires that the affidavit, 100 affidavits have to be filed. Our position is that these are not valid affidavits. The board, under Chapter 55, Section 7B, which this hearing is being conducted under, I think gives that authority to make that type of decision.
I'd like to hear our counsel on what you think of the wording. Is it the difference
Well-
under and legally?
Well, I think that's a problem because, I think it's a problem in that final paragraph because that's not the actual language. I think it is what was intended, but that's not the actual language of the statute. However, you do have that introductory paragraph that has that language in it, and that language is correct in the first paragraph, on the first page. Not the first paragraph, it's actually the second paragraph, but it's on the first page.
Can I look at the first page again? I'm sorry.
Sure.
Thank you.
Mr. Chairman, if there's nothing further, I'm prepared to make a motion.
I don't have anything further.
Nothing further.
I move to overrule the objection on the grounds that the beginning of the documents that were filed contains the statutory language of an affidavit, and it meets the statutory requirement.
I second that.
Having been motioned by the city attorney, seconded by member Pereira, excuse me, I'll never get it right. Pereira, thank you, that's better. All in favor, say aye. Aye.
Aye.
Unanimous to overrule the objection. The objection is overruled.
Next, I'd like to address paragraph 46. Referring to the chalk that is Exhibit 1, at the, on page 5, I believe.
Just again, for clarity on the record, it's joint Exhibit 1, in anticipation that there might be Exhibit 1s that aren't joint.
There's a funny echo, I'm sorry.
Yeah, I know, I'm having a difficulty with it too. What I'm saying is, it's a joint exhibit. I want to distinguish a joint exhibit from Exhibit 1 that might be offered by the objector or the mayor, however we want to phrase it, and an objection, Exhibit 1 that might be offered by the affiance. So I'm just clarifying for the record, it's joint Exhibit 1.
Just for a point of order, I intend to go down the line through the numbers till we run out of numbers.
So you're not
And then
gonna-
mark
you're
them
not-
jointly, have them joint or presented
So you're
by.
going to do,
This is one
so
joint,
3 might be Exhibit 3. So
Exhibit-
let-
that's
But
correct.
nonetheless, let's call it joint exhibit for the record.
absolutely. One joint,
Okay.
two joint, three proponent, four opponent, et cetera.
I'm sorry to interrupt you, Mr.
No problem. Joint Exhibit 1 on page 4. Again, the chalk is broken into ones that were counted and ones that were not counted. And on towards the bottom, there's a blue line that says grounds total, that in each one of the grounds totaled up, and again, is the number of signatures, number of affidavits that has that ground checked. If the board does nothing else in terms of any of our objections, accepting any of our objections, and if everything stands, ground 1 has 114 affidavits that has ground 1, ground 2 has 86, ground 3 has 97, ground 4 has 102, ground 5 has 102, ground 6 has 104, ground 7 has 115, ground 8 has 93, ground number 9 has 98, and ground number 10 has 106. If the board rejects all of our objections, and it stands as it is now, and as it was certified, our objection is that if a petition is issued, that grounds 2, 3, 8, and 9 not be listed on the initiative, the recall petitions, if in fact they are ultimately issued. That's my objection.
Briefly in response, there is nothing in the city charter at section 9.7 that requires unanimity in the types of grounds. And the way this petition, the way these affidavits were written, and it's very clear at the second to the last line in the first paragraph, any allegations contained herein that are on information and belief, I believe to be true. These affidavits were designed so that people, if they so chose and had personal knowledge on any one of those 10 issues, could say so. If they had personal knowledge on all of those issues, they could say so. So I don't think it requires that the grounds have 100 people. there is a requirement that 100 or more affiants have grounds. That's all I want to say. Thank you.
So if there were only a single check on each affidavit 100 times, and we didn't reach 100 on any of them, we could still proceed, in your opinion?
In my opinion, the charter requires affiants of 100 or more to submit affidavits, and to list grounds.
They only need one ground.
Yes, that's our position.
We would need 100 for each ground.
No, you need 100 affidavits.
whole.
You need 100 affidavits or more, 100 or more affidavits that list grounds, any grounds. They don't have to be all the same grounds. These are because affidavits require personal information, knowledge, and belief. So we know there's some people who knew of some specific allegations personally, and we know that some people did not. And that's why they were given a choice of picking 1 through 10. And I don't think it requires that each ground reach 100. Thank you.
Mr. Farah, if I may, before you leave. Correct me if I'm wrong, I don't think you're saying that, and again, this is just an example, if none of the grounds were marked, we would still have an affidavit, is that right?
Still a valid affidavit. I believe there are 4 of those that none of the grounds were marked, but it's still an affidavit asking for a petition issue for the recall of the mayor.
But hypothetically, if none of them, in all 181, none of the boxes were checked, then that would be sufficient, just hypothetically. Is
And
that-
I mean, it's a hypothetical question. Our position is if you file an affidavit, it's suggestive that you want this mayor removed and you want the Board of Registrars to issue a petition, whether you check one off or you don't.
So the key language would be that checked off below are various grounds upon the personal knowledge and belief which exists to support the recall, et cetera, et cetera, et cetera.
That's right.
I just want to hone in
The
on what
city
you're
charter
suggesting.
state that a ground is required in order for an affidavit to recall the mayor?
Boy, I got to tell you, this has been the subject of a lot of legal discussion amongst a lot of learned people, and I don't believe it requires a ground. I think it just requires an affidavit. The affidavit is unique. It's very different than voting in a voting booth with a curtain. It's some brave person standing up and lending his name and his address and his opinion to the governance of our city. So I think it's as extreme as you can get as an affirmation of your position and your desire to vote and why you want to recall.
Ms. Farah, if we were to remove from the affidavits all the language in items 1 through 10, what would it say?
I don't think I understand that. I'm sorry.
If you're saying, if
No ground is required.
you're saying no ground is required,
Yep.
then we can simply have a piece of paper where someone says, under penalty of perjury, my name, and turn it in.
And I want to recall.
And
Yes.
And that's an affidavit.
But I want to make sure that the city charter states that a person can state that and sign it, and it can be an affidavit. With no
An
ground,
affidavit for recall.
no, an affidavit for recall, no grounds needed.
No grounds indicated. Yeah, checked off and indicated.
Checked off.
I have a comment, but I think I'd prefer to wait until after we've heard everything that the parties have to say.
Thank you. Sure.
Quoting from the charter, recall petitions, 100 or more voters may file with the city clerk an affidavit containing the name of the officers who recall is sought and a statement of the grounds upon which petition is based, not less than 12 months prior to the expiration of the term of office. The names in the affidavit shall be from the city at large. So it has to be listed. It can't be just name, because otherwise it wouldn't. And in fact, later in the charter, it calls that those grounds actually be on the petition that is circulated at large for the 15% signatures,
And so doesn't that answer your objection right there?
which,
You're objecting, saying that there aren't significant signatures for certain of the grounds, and yet, if I look at paragraph 45, it says, it requires the city clerk to provide blank petitions that shall contain the names of the persons who have filed the affidavit and the grounds for the recall as stated in the affidavit. So, if you have to put the grounds in that are on the affidavits, then the fact that there weren't 100 of them, doesn't the charter still require that everything be contained on the petitions if and when they're issued?
I don't believe so, because if they had 99 affidavits, you wouldn't list any of them. And in fact, there are 3 affidavits that don't have anything checked.
Well, if you had
Let's-
99, excuse me, go ahead.
Let's do that a little differently. Let's say I have 99 affidavits that check off the same 9, and I have one that just checks off 1. Do I have 100?
That's number 45 on my objections.
You're ahead of us.
That's how I roll. Thank you.
I have one question, if I may, Mr. Newman. And it's in relation to the question asked by Registrar Pereira? Pereira, thank you. She asked you, and you read from the charter, and you started to read quoting the charter, and then you deviated by saying, well, grounds kind of means a list. Aren't you interpreting the charter there?
I'm not interpreting the charter. The question was, does the charter ask for grounds? And it does, and I read the charter.
Yes, and then you
I went
said,
into argument.
it then implies, or you didn't say implies, you said that requires a list. I heard it very clear.
That it requires a list?
A list. The grounds require that a list be provided
No.
to reference those grounds.
The grounds have to be listed on the petition that you would put out,
I stand corrected. The grounds have to be listed on the petition,
on the initiative petition.
which would be
yes.
a list of those grounds.
The ones that have over 100.
But the city charter just says grounds, doesn't it?
Mr. Maloney?
I'm asking Mr., just to look at the charter.
100 or more voters may file with the city clerk an affidavit containing the name of the officer whose recall is sought and a statement of the grounds upon which the petition is based.
It doesn't say list.
Later in the charter, the city clerk shall deliver to the state, to said voters, petition blanks demanding said recall, printed from which he shall keep available. The blanks may be completed by writing or typewriting, and they shall be addressed to the city council. They shall contain the names of the persons who filed the affidavit and the grounds for the recalls as stated in the affidavit.
Grounds. Anyway, I'll stop there. I appreciate reading from the charter.
And if there were, if there were 100 affidavits that had all the grounds, then you would list all of the grounds on the petition. My contention is that there are four grounds that there are not 100 affidavits for in this objection. Another objection is a little bit broader than that, but in this objection, regardless of what the board does tonight on any of our objections, there are currently 4 grounds that 100 people did not sign for. So if someone name was on it and they didn't sign the petition, it would seem like they were in favor of those grounds when in fact they weren't.
Got it. Anything else?
I'm good.
I'm sorry, are they finished?
Additional rebuttal or no?
I don't know. Rebuttal? Counter rebuttal?
The charter speaks to the term of grounds with an S, not ground, singular. It's in the plural. It does not require 100 people have unanimous affidavits on each point. And I understand what Mr. Newman is saying, but the charter, if we have to follow some guideline, if we have a roadmap, it's that charter. And the charter wants the grounds, plural, listed. I may be one affiant who has one issue, but I am one of 100 or more affiants who may have that issue and some other issues as well. All 10 of those grounds, in plural, should be listed on the petition. That's what the charter requires.
So you may be an affiant with one issue, but you are seeking to have that issue applied to the same recall as the other affiants.
No, I'm seeking to have my one issue brought to the attention of the 5,645 petitioners, hoping that one of them agrees with that issue. That's the point of it. So, someone may come along and say, look, I've read all 9 of these and I disagree with 9 of them, but there's one that I agree with. That's the point of it.
To me, that seems scattered. I would have rather seen the signature, but I'm still not understanding. I understand that the charter states that it's grounds,
Yep.
but I'm having trouble understanding that someone can just sign a general, list of 10 and agree as a whole to.
If some affiant has come along and they've checked off 10 of these issues and they have personal knowledge on the 10 of the issues, then that qualifies as an affidavit.
That would make me feel better.
Well, it doesn't make me feel better because I wouldn't expect too many people in our city, unless they were intimately involved in the goings-on of the city, to have all of this knowledge.
And
Now,
what I would expect is separate grounds and separate signatures, right?
you would have a petition that nobody could fill out. And I think, once again, coming back to my point earlier, is if one of the affiants is brave enough to come up and lend his name and his address and his credibility, this is why we list the affiants. This is a campaign, and if he's brave enough to do that, and he has one singular issue, and there's somebody who comes along reading this petition and says, yes, I'll sign it because of your one issue, I agree with you on your one issue, then that's a petition signature. That's why the grounds in plural are put on, and the list is put on the thing. It could be as minuscule as one issue. Dennis?
Under Mr. Farris' theory is that if he had 10 people sign ground 1, 10 people sign ground 2, 10 people ground 3, there were 10 for each, then that would be sufficient to have the recall petition. So if 10 affiants put ground 1, the next 10 ground 2, the next one ground 3, 4, 5, 6, 7, 8, 9, 10. So only one of 10, under his theory, that would be sufficient to trigger a recall.
So,
You need 100 affiants.
No, that's 100 affiants.
You need, no, it isn't, it's
Slow down,
100
slow
lists,
down.
it's 100 objections. It's 100 grounds. You need, this isn't 10 affiants with 10 grounds each. This is 100 affiants with their own specific grounds, because it's an affidavit. An affidavit is based on personal information, knowledge, and belief. There's no other way around it.
With a minimum of 1 ground each.
Minimum of 1 ground.
so let me ask this question. I may have the case wrong, but I believe it's something like Muck Wazowski versus the town of Hadley. And in that case, the charter provided that a recall, similar to Lawrence, had to be commenced with an affidavit. And the language in the charter said that the affidavit had to provide grounds for the recall of the elected official, something along the lines of, and I've had these conversations with each of you, for malfeasance, misfeasance, nonfeasance. An affidavit was submitted, and the grounds stated in the affidavit were malfeasance, misfeasance, and nonfeasance. Mark Rosowski, who was the elected official whose recall was sought, challenged that, I think, and he said that you have to give substantive grounds. It's not enough to give generalities. You have to point to a couple of things that this individual did that were wrong. And the court disagreed. And the court said it's enough to just say, in general terms, malfeasance, misfeasance, and nonfeasance. You don't have to get into specifics. What's controlling and what's sufficient is that there are 100 affiants who express their will that the elected official be recalled. That's what I understand that case to mean. And I'd like, if you can or care to, I'd like you to address why that wouldn't be the case here. If you have 100 affiants, who express the desire to recall an elected official, why does it have to be on specific grounds when in Mike Rosowski it didn't have to be? Why would it have to be 100 of these particular grounds?
When the affidavits were written and the foundation sat down and talked about leadership in the city, they came out with a list and they pared it down to 10. I agree with you that this is like a vote. God knows why we vote the way that we vote. But it doesn't require grounds to vote somebody into office, but it requires grounds for someone to be recalled from office. And the charter, erring on the side of the charter and trying to do it right, in trying to make their case to the petitioners, people who are going to sign it, they listed grounds. And as I said earlier, if one ground is enough to get one petitioner to sign a petition because he agrees with you, that's the intent and the effect of the recall petition. Dennis?
I believe that case can be distinguished. In that case,
So do you agree with my summary if you're now distinguishing it?
I agree with your summary, I disagree with your conclusion.
Okay.
In that case, the court found that they weren't challenging, they were challenging the sufficiency of the grounds, not that there wasn't 100 grounds. In this case, we are not challenging the sufficiency of any grounds, 1 through 10. We are challenging the fact that as they stand, without any of our objections, there are 4 grounds that don't have 100 signatures. 100 people have not agreed to grounds 2, 3, 8, and 9 on what you have in front of you.
So would it be possible, therefore, assuming that your argument were correct and adopted by the board, would it be possible, therefore, for the city to issue petitions and still comply with Section 9.7B, which requires that the grounds be stated on the affidavits? The grounds that appear on the affidavits be stated in the petitions. If we're now going to exclude them, as you suggest, bear with me for a second, if we're now going to exclude 4 of these grounds because there aren't 100 affiants who have personal knowledge of them, how can we then comply with the other provisions of the charter which require us to, and I'm using your own document, and the grounds for the recall as stated in the affidavit? If we have 30 people who've given that as one of the grounds, how can we issue a recall petition and not include the ground that they did testify to?
There's not, if they,
Wouldn't we be opening ourselves up if we then were to issue petitions? And I'm interrupting you, but I'm just trying to clarify. You know, here's the thing, okay? This is an initial hearing on the affidavits. Then we're going to issue, if the board finds sufficient grounds to do it, a recall petition. and that recall petition may be challenged too. So aren't we opening ourselves up, if we agree with you for the moment and say that there are only 30 people who signed paragraph 2, grounds 2, so we leave that off? Aren't we now opening it up to be challenged by the affiant, saying, why is that ground left off? Because although there weren't 100, I did put it in there, and the city charter says it shall contain the grounds for recall as stated in the affidavit. And that's a quote that you, counsel for the elected official, provided to us. I don't want to go through endless objections from one side or the other, so how do we reconcile that?
Well, I think that it's clear that if those 4 grounds don't have 100, they shouldn't be listed, because it says it has to have 100 affiants that sign and what the grounds are. If they don't have that grounds, the flip side of what you asked is that if they, the 3 people that didn't sign any, they're being listed as all 10 are being listed as if they are, saying that all 10 are grounds that they feel. So it's the flip side. I think it's clear that if there are 4 grounds that don't have it, they should not be listed on any recall petitions if issued. And again, 45, I get into a larger, broader thing that I think a definition of what affidavits are and what the patents are. And if the board agreed with that, then it would make all the other ones moot. I doubt that will happen, but I am putting it on the record. Also, if there are on some of these other issues that we have, if the board agrees with some of these issues that the affidavit should not have been counted as we get into the lower ones, there's a couple of grounds that are pretty close to 100, 102, 106. If in fact we were able to disqualify 16 affidavits that had number 7 checked, and 15 that had number 1 checked. Most of the other ones, the one that have 102, 102, 104, 106, if we are successful, and that's obviously a hypothetical, if we are successful and the board agreed with us on some of the other grounds that affidavits should not have been counted, it may bring one more or all of the affidavits under 100. And I would argue, as I argued this, is that any that goes under 100 should not be listed on any petitions if issued.
All set, Charles? You think, Mr. Chair? It's like you're boiling over.
Mr. Hammond? Mr. Hammond?
Mr. Newman?
By your logic, by this logic, if I had just 2 grounds on the affidavit, and they were 50 and 50, and I had 100 affidavits turned in, I couldn't issue a petition for recall.
That's our belief, yes.
But I have 100 affidavits with at least 1 complaint checked off.
I think you don't have 100 that state the same ground.
I don't have any other questions.
I just want to hear the city charter on it again. I'm sorry.
Well, I don't have
Because
the,
of that,
I
because if
didn't
we
bring a
had
copy of the
2,
charter.
I don't have the
50 and 50,
I'm sorry.
go ahead.
No, I was interrupting you. Go ahead.
Yeah. So because of that very reason, if we had 2 50 and 50, it equals 100. And if we have 10, random, it still lends us at 100
If there were 100
affidavits for recall.
If there were 100 reasons, and everyone checked off 1, we'd be issuing a petition for recall.
Because of the wording on the very top.
And it would be huge, But that's what the charter says.
No, the charter,
It doesn't
the charter
say-
says,
It doesn't say that every single person has to agree with every single reason. The reason could be the moon is made of cheese.
reason
It's
could
still
be
an
what?
affidavit.
could be what?
The reason could be as nonsensical as the moon is made of cheese. If 100 people agree, I have to issue a petition to recall the mayor.
I don't think it's his fault.
So their will is kind of stated in the very top of the recall petition. I want to hear the city charter just
Well,
one
the
last
city
time.
charter, as it's referenced in paragraph 45, says, "The city clerk shall provide blank petitions that shall contain the names of the persons who have filed the affidavit and the grounds for the recall as stated in the affidavit." I think that when it comes down to this issue, we get back to the very basic tenets of election law, which is the will of the voter should rule. And I think that that's exactly what that Makrozowski versus Hadley case is about. It says, if I'm not mistaken, in the holding, that it's not necessary to have specific grounds, but, and this is the operative thing, I think, in our situation, merely that there be 100 registered voters who seek to have the elected official no longer serve. And that being the case, I think that it's irrelevant whether there are 100 affiants on any particular ground, so long as there are 100 people who think the individual elected officer should be recalled on any ground.
Again, I respectfully disagree, because I think the case
I
talks about,
suspected you would.
the case talks about the sufficiency of the grounds. We're not contesting the sufficiencies of, we may disagree with, but we're not contesting the sufficiency of any grounds. If somebody, it's asked for affidavit and the reasons why, and if the reasons, as you pointed out, if there's 100 affidavits that have 100 different reasons, that's not an affidavit that has 100 affidavits with the same grounds. And I think it's clear that there's 4 grounds that don't have 100.
When I first saw the affidavit, I thought the same thing, that it was a bit scattered. And I wondered immediately if any of those, each of those grounds had enough, 100. But it was kind of clear to me that it was, headed with a recall. Their intentions were clear. So if I was going to sign something, I would pay attention even to the heading, regardless of checking. So the intention was there and it was made clear. And it
as-
sounds like the city charter kind of welcomes grounds, so multiple grounds. I personally I like a more specific document where it may be just one ground, but that would be in an ideal world, right? Just one ground and it's kind of clear signature under penalties of perjury. But it's not the case, right?
And it doesn't disqualify.
And it doesn't, that's kind of where I'm,
So
yeah, sorry.
I would then move to overrule the objection.
I second that.
All in favor?
Aye.
Aye.
All right,
Signify by stating aye.
Aye.
You in aye. Unanimous, the objection is overruled.
I need a break.
5-minute recess?
5-minute recess.
2 minutes.
Sorry, folks, 5-minute recess. All in favor? Aye. At 8:25.
Oi, 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 oi.
8:30 now.
My pen.
I got him a ride.
Motion to resume proceedings. Motion to
Sorry,
resume
second-
proceedings?
Second the motion.
Second, all in favor, say aye.
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 Aye. Back in session, please.
Number 45,
Yes, sir.
this argument is similar, and I won't belabor it, but I do want to put on the record that Exhibit B, which we had included, has the different types of affidavits, the patent on each, and none of them have, none of the affidavit patents have 100. The one that has the most is 65, I'm sorry, one that, affidavits that have signed, checked off 1 through 10. There's 65 of those, and then there are a couple that have 10 and 8 and 7, and then probably about 30 that only have one patent. The argument is the same, is that on those particular cases, that the patent is different, so the affidavits are different, and therefore none have 100. And the only one that doesn't even really come close is the patent that has 1 through 10, and there's 65 of those. So I think that all the affidavits fail for that reason.
Attorney Newman is correct. This is the same argument that was just made moments ago. And I don't want to rehash it too much, but as we discussed, and you, I guess, correctly voted, that every affiant can have one ground, or every affiant can have more than one grounds. But the charter requires that that ground be placed on the petition. And it's very akin to the previous objection that they made. Thank you.
I have nothing further.
I have no question.
I have none.
I move to overrule the objection.
Second.
All in favor, say aye. Aye.
Aye.
Aye.
All opposed? None being opposed, unanimous. The objection is overruled.
Paragraph 44. I cited it in our objection, but I'd like to give a copy to counsel of a case. Yeah, I'm sorry, I thought we had mentioned this. I gave one to counsel. Opposition is that, and again, there are a number of inactive voters who sign affidavits, and that opposition is that a law is that if someone who is an inactive voter goes to vote at the polls, in order to vote, if they are on the list as an inactive voter, they need to fill out a affidavit of present and continuous residency and show a photo ID. Our contention is that these inactive voters, and there's a list on the chalk of the ones who are inactive, were not eligible to sign the petition. And I cite the case of Fricolatus versus the city of Springfield, which was in 1999 case. There was a special election for state rep, a Democratic primary. A gentleman named Keogh was running against Fricolatus.
Frintilakis.
Easy for you to say.
Caristo.
He knows.
The Keogh won by 31 votes. After recount, it was 32 votes. Mr. F. Contended in Superior Court that about 45, I think it was 49 people voted, but they were an inactive voter, and they neglected to fill in a petition of current and continuous residency and show a photo ID. Through no fault of their own, actually, the warden did not request that. The Superior Court said that those votes should not have been allowed and ordered a new election because the number was larger than the margin of victory. And under McCavitt versus the City of Brockton, they ordered a new election. Mr. Keogh obviously appealed that to appeals court. The appeals court agreed with the Superior Court that they should not have been counted, but that it wasn't totally fatal, that they could give evidence after the fact that they were in fact in fact eligible to vote because they would then file a affidavit of current and continuous residency. Therefore, we think the petition fails because the number is that, at least for now, however, it could be cured by those voters coming in to the clerk's office and filing an affidavit and showing an ID. The standard for signing an affidavit should be no less than to vote. These affiants are asking the City of Lawrence to spend tens of thousands of dollars potentially on an election, a recall election, to recall the mayor of the city, so that the legal requirements should not be any less than they would be for that same individual to actually go and vote.
There is no reference in the city charter, pardon me, there's no reference in the city charter that requires the affiant to be an active voter or an inactive voter. It's silent on the issue. It just says a registered voter. But if you reference this case that Mr. Newman has presented to
Do you have a copy of the case?
I do. He was kind enough to give me one. And please don't ask me to Fintrilakias. Close? Yeah.
Yeah, I'm going to mess it up myself.
If you look at page 468, it talks, this, by the way, this case was a case about a state election. It was not about an affidavit in support of a petition for recall. But if you look at it, it references 950 CMR 54.046A. And I'll read it to you. Quote, "The presiding officer shall allow such inactive voter to vote upon written affirmation by the inactive voter of his current and continuous residence in the municipality, signed under the pains and penalties of perjury." I would suggest to you that the affirmative act of signing your name to an affidavit under the pains and penalties of perjury for the purposes of initiating a recall petition activates one's right to be a voter. And it's just gilding the lily. It's a firmer affirmation of one's intention to involve himself in the electoral process in the city. It isn't required, but an affidavit, in my mind at least, recertifies one's intent to be a voter. Thank you.
Mr. Chair, if I may. Mr. Newman, I just happen to have 950 CMR 5400 in, correct me if I'm wrong, what you're suggesting is that in order to sign an affidavit for a recall, you have to file another affidavit, right?
Yes.
So an affidavit upon affidavit to file a petition.
No, the requirement, as you know, is in order for an inactive voter to vote at an election, they have to show to the warden, sign an affidavit that you provide for present and continuous residency, and to show a photo ID. I don't think that the requirements for signing.
But I'll stop you there. I do mean to interrupt you. It does not require a photo ID. and I know that intimately. In fact, it requires the identification procedure that
I'm sorry,
is
I stand
required by
corrected.
the
I stand
federal
corrected.
law. And in
I
fact,
stand
doesn't
corrected.
require a picture.
I stand corrected.
Okay. I mean, that, and I
I meant
raise this
it's
point, and I
identification.
hate again to interrupt you, but I raise this point because it's a common misunderstanding throughout the Commonwealth, and in fact, strongly misunderstood in the city, that voters who show up at the polls who are inactive are somehow have contracted the plague and shouldn't be there, and they should be denied access to the ballot.
I'm not suggesting that.
Well, you're asking us to deny them access to an affidavit.
No, I'm not. I'm just saying that they should have the same requirements as it is to vote, to sign an affidavit that will potentially trigger a recall election.
Is this listed under 268, Section 1, affidavit requirements?
I'm not saying that the affidavit is not correct. I'm just saying that they were not eligible to sign the affidavit. So no, it's not, but I'm not suggesting that it is.
Correct me if I'm wrong again. My understanding is that an affidavit is controlled by 268, Section 1. All affidavits of any type, any form, that if they're not truthful or someone lies, they potentially can go to jail. It could be a felony. So isn't it enough that they're signing an affidavit? They need 2 affidavits in order to go to jail. I guess it's rhetorical. I guess my real question to you is this, and answer it if you can, and I know you're a very good election lawyer, I know you are. Is an inactive voter a registered voter?
If they refill the requirements of, at the polling time, the time of polling, of signing an affidavit of current and continuous residency, and they show identification.
So conditionally, their inactive voter may not be a registered voter. So in your list of registered voters here, there's a number of inactive voters, I'm sure.
That's correct.
And if they're listed as inactive, they shouldn't be allowed to vote.
I didn't say that.
Are they registered? Point blank.
I don't believe, I think they are inactive voters.
Are they registered? Yes or no?
They were registered. The
So they're-
the statute requires for them to vote because they haven't, as you know, they haven't voted in 2 elections. They have not filled in the census, that therefore they're put on an inactive status.
But he's not asking you what's required for them to vote. He's just simply saying, are they registered?
That's simple.
I think they're registered as inactive voters.
So they're registered. They're just registered as inactive.
Mr. Maloney,
Yes.
can you give us what the requirements are for, in the case of a recall for a registered voter who is not, who's inactive? What is the rule?
Inactive voters are registered voters, period. There's no other requirement
Okay.
that I am
And
aware of.
what other
I
steps
think
that
they
they
have
have to
I
do?
think, to answer your question, I think that they have to comply, and my understanding is they certainly have to comply with 268, Section 1, to be truthful. If they're not telling the truth in their affidavit, then they'd be subjected to the pains and penalties of perjury, and that's what that phrase means. It doesn't mean you're not to be counted because you're inactive.
In the case that I handed out, both the Superior Court and the Appellate Court found that those people were not eligible to vote because they had not refilled that requirement. The Superior Court said it was fatal and could not be cured. The Appellate Court said it could be cured after the fact if they came and made, and fulfilled the
I
requirements.
love this ground.
But in the case you provided, this was an election,
That's correct.
right? And this was an election where they had inactive voters come to the poll, and they did not do their duty in having these voters present ID and get
That's
a
correct.
ballot properly.
That's correct. And
Now,
also,
there are other actions by which a voter goes from being inactive to active. Are you aware of these other actions?
They could come down, they could fill in the census. They could come down to City Hall and fill out an affidavit, or when they vote, some of these people, actually, the gentleman here tonight said he had voted in the preliminary election. I assume that he became active at that point by fulfilling the requirements.
Or sign a petition?
Except that when he signed the petition, he was not an active voter.
Signing a petition can activate you?
Or nomination paper, anything.
On a nomination paper? On something that is election-related, including an affidavit for petition?
I disagree.
What is the law?
I don't believe that there's ever been a case interpreting that. I mean, if you sign a nomination paper, that is grounds for reactivation, I believe. But with respect to signing an
Could
affidavit.
you speak so we can all hear it?
Oh, I'm sorry.
Into the mic.
With respect to signing a nomination paper, you sign a nomination paper, that's one of those actions that will take you from inactive and reactivate you. With respect to an affidavit, I don't think there's ever been anything that's interpreted that. However, since, we've distinguished between two phases in the recall process in the city of Lawrence, the first phase being the filing of an affidavit, the second phase being the filing of a recall petition. We've determined that a recall petition, I think everybody agrees, requires a certification with its inherent objection period. Filing that petition, I think, would be an act which would activate you or reactivate you as a voter. In this instance, we have the objector arguing that we should treat the affidavit like a petition. We've said no, but since they've argued that it should be treated in the same manner as a petition with an objection phase and of course the certification phase, then arguably, if we treat it like a petition, then similarly, it would be a reactivating occurrence.
And of these reactivating occurrences, other than voting, which ones require ID?
That I don't know, but
Do I need ID
Clerk
to
would
submit
know.
my census?
As a general matter, I would, in answer to the city attorney's less rhetorical
I
question,
think it's just voting.
people who are inactive are sent confirmation notices, as you know, Attorney Newman. And we don't, and those are affidavits, because they're signed under the pain and penalty of perjury, because I draft them. I get those back from inactive voters, and I've never taken an ID on confirmation notices, nor does the statute require it.
I think it's silent to that. But that, I
As
mean,
I
if
as
they...
I say, and I'll agree with that it's silent to it, but we send these out in mass throughout the Commonwealth, clerks, I mean, and they go out by mail. I am unaware of any clerk's office that requires an identification form to come back. I think they're self-verifying in the sense that the ID procedure in Massachusetts requires only a piece of mail, essentially, at minimum, reflecting the voter's address. So in that instance, answering the city attorney's instance question, where ID may not be required, I don't see it required on confirmation notices. In a similar fashion, I also don't quite see them required in general on a statement that happens to be an affidavit that's governed by other laws and has much stringent or much more strict or stricter penalties. Anyway, that's neither here nor there. I'm sorry.
No, that's all I got.
I'm satisfied, thank you.
Thank you.
No, I don't have any questions. Mr. Mahoney?
I move to overrule the objection.
I second that.
All in favor signify by stating aye.
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 Aye. All in favor unanimously say aye. Anybody opposed? What was that, number 44?
Yep.
Thank you. Mr. Chairman?
Next objection, please.
I'm going to hold signatures do not have registration cards, number 43, in abeyance, and go to number 41 and 42. Two people who signed the affidavit and requested that their names be removed prior to certification. And I'd like to submit that although it was filed with the clerk, I would like to submit that into evidence.
Are they here tonight? Through the chair, may I ask? Are they here tonight?
They are not, I don't believe so, no.
Do you have copies of the objections that you filed with the clerk with you tonight?
Yes.
Is it your intention to offer those?
I would like to offer that.
If I may just continue for, do you have objection to this?
I do have objections.
Before you object, can I,
All right.
I'm not, almost done.
Can we,
I would also, and again, I didn't bring,
Yeah, in comment, yeah. Number 3, 4, and number 5 for identification.
oh, I'm sorry.
Yeah, you should have both of their thingies.
You have the, okay.
For the file, but I want to get copies at some point.
Yeah, I appreciate it, thank you.
I just gave to the solicitor 2 cases and to Brother Counsel, 2 cases, McBride versus the City of Chelsea. It's a recall of the mayor of Chelsea back in, way back, in 1984. And the issue was specifically, there were 2 issues. They were actually, they weren't on affidavits, but it is, I think it is instructive. There were 2 issues that were dealt with at Superior Court and then later in the appellate court. The question was whether someone could remove their names from the actual recall petitions before they were filed, and could they remove it after they were filed, but before they were certified. Superior Court ruled that in both cases, those names could be removed. The appellate court agreed that if they asked to be removed before it was filed with the clerk, it could be removed. On the question of whether or not it was, they could remove it before certification, the court, in the dicta, kind of indicated that they probably would not go along with that, but they did not make a decision, saying that
probably-
they did not have to, because there wasn't enough other signatures.
Okay, in the dicta, it said what again, please? I'm sorry,
In the
that
dicta,
echoed.
in the dicta, it lean towards, without saying it, that they most likely would not have agreed,
I'm sorry, most likely would not, what?
have agreed and removed
Have
them.
agreed to allow it to be removed?
So opposite what I'm arguing.
Okay.
So, it is not, but the Superior Court did agree that it could be removed. So I'm quoting obviously, I favored the Superior Court decision, and the Appellate Court, again, did not rule. Left the question open.
And for clarity, I know you did submit the purported withdrawal. I guess I have two questions. The first is, when were these received by the, okay, so
September 4th.
9/4
which is-
was
I-
after it
I
was
do-
filed.
I do have personal knowledge of this.
No, that's okay, I'm just trying to understand. So were these filed, well, we didn't do a certification, really, so I guess,
Verification. is
yeah,
what I-
prior to verification.
No, they were filed after.
The withdrawals were filed after?
These were filed after. I
I'd just
received
like,
these
I'd
after.
like Mr. Newman, respectfully, I just want to hear what.
I move to remove them at any stage, too.
I'll second that. I'll second. Well, no, actually, I think,
Well, whether it was after but it was, he had already reviewed the submission, right? When they came in,
okay.
or not?
I,
Regardless.
I defer to Mr. Newman at this point. I think that's what the city attorney
no,
was
but,
asking.
yeah, but you know what, she just said irrespective that she would, allow them to be withdrawn.
to withdraw.
But, okay, and I think I might second that motion, but I just have a question, well, I guess we have to allow rebuttal first. But, I have a question, since they're not here, and I'm pretty sure I know the answer to it, but I think it would be remiss if I didn't ask. Carmen Ferreira, she's also known as Carmen Burgos?
I don't know the answer to that.
They're two
They're
people.
two separate
They're
people.
two separate people.
No, well, okay,
There's Carmen and Denise.
That's right.
right. And so Carmen Ferreira has asked that her name be removed from the thing, correct?
They both
Yes.
signed.
They voted.
They both
Yeah, okay.
Okay. Yep.
So, and they are which numbers, counsel?
They are number
117.
117 and 162.
Okay, so 117 is who?
117 is, I think it's Carmen,
It's Carmen,
Carmen Ferreira?
yes.
yes.
Who's Carmen Burgos?
I think that could be a maiden
Denise
name.
Burgos.
Okay.
It's
No,
Denise.
the driver's licenses that were provided both say you have Carmen Burgos and Denise Burgos. I'm trying to find out if Carmen Ferreira, who signed this, has the ID of Carmen Burgos. I'm trying to make sure they're the same person. That, for the record, you're representing that Carmen Ferreira, who is listed as 117, who signed this as Carmen Ferreira, is now looking to withdraw. I've got a question because the the driver's license, the photo ID that you provided says Carmen Burgos. I'm assuming they're the same person. I believe that's what we're gonna find out, but I'm looking for some evidence of that or affirmation of that.
It looks like in the license, she also signed Carmen F., which I would think it indicates Ferrera.
I believe, and the clerk would probably, I think, know better than this, I believe they came in, they didn't give that to me, they came in and I believe they
let's
filed
take
it here.
Can we take a look at 117?
Yeah, he's
When I-
here.
Wait a second.
Here it is.
You have it? With the, do you have the registration card, though? No, I'm not looking, I'm not looking for that, I'm looking for the 117 that has the registration card with it.
Let me see
Because
that.
maybe the registration card says something about Burgos.
Yep, I see what you're saying. Good idea.
Good.
117, no, 53B.
I'll tell you in a second.
One 100,
Just seeing if it's one of those that was registered but no card. I'll check it. Or, not registered.
Dennis, do you have the registration card for Carmen Ferreira Burgers? Burgos Ferreira, whatever? Do you happen to have that?
I think I handed it to you.
No, he's just handed the, he just handed the affidavit, is what you gave us. There wasn't a card attached to it. And I'm checking the cards now.
These aren't, mine aren't in order, that's the problem I'm having.
Neither are mine, so.
My apologies.
Okay, then that makes me feel better. 123,
Yeah, mine not either. I thought they were. My apologies.
Carmen Ferreira.
Got it?
Okay, got it.
I got it too.
Carmen Ferreira. Former name Carmen Burgos,
Got it.
112 Jackson Street.
So that-
Okay, I'm good.
That answers that.
Are we set in terms of the question?
I am, yeah, thank you.
Thank you.
Yeah.
That was good.
My only comments would be, I would like the opportunity, since the burden is on Mayor's Council, I would have liked the opportunity to ask Carmen and Denise, when they were contacted, whether they initiated a desire to renounce this affidavit, or if somebody had spoken to them. And to the extent that we're working on this paper, this is not an affidavit, it's certainly joint. It's got-
Which paper are you
I'm
referring
sorry, I'm
to?
waiving this, and it's we, Denise Burgos, and Carmen Ferreira.
The withdrawal, which I think we've marked for
Identification.
Yeah, what is that, exhibit
identification as what?
3?
Number 3 for identification.
So I would have liked the opportunity to just gently ask them questions. Who initiated, did you initiate a desire without undue influence from anybody else to withdraw this petition? I'm sorry, I keep saying this, forgive me. The affidavit. And the form of Exhibit 3 attributes a statement to two persons. I don't know how you do that. I would have felt more comfortable if they were individual, and I would have felt much more comfortable if they were under the pain and penalty of perjury. Having said all of that, I do defer to the city clerk, who may have personal knowledge, and we will accept the personal knowledge of the city clerk as definitive, at least with respect to our objection to this.
I would, okay, so if I would
There
wonder
is-
if
there
this
is a
person was
motion-
solicited.
There is a motion on the table, it hasn't been seconded. It was seconded at this point?
I-
Before we go into further discussion? Having heard both rebuttal and the proponent of it.
I'd like, no, I'm not gonna second it at this time.
Floor is yours.
Our motion holds, right?
No, there's no motion seconded yet.
Motion would fail for lack of a second,
Right.
unless somebody wants to second it at this.
I'm not prepared to second it either just yet. I don't think the
For the
discuss-
removal, I got
don't-
lost just
I
now
don't-
with you.
I don't think the discussion is over yet. That's what I'm saying.
Oh, okay. I
Yeah.
thought the discussion was over
No,
and we had
I-
voted to remove them.
I would like the opportunity to comment, certainly at the invite of
I was gonna
Mr.
comment
Farah,
to
but
what
go
Mr.
ahead.
Farah said.
Yeah, go ahead.
So one of his questions was whether or not these were solicited, right?
Yes.
These were solicited too, the recall, right? So I would, they were presented to people. So I take this just as the will of the voter to remove what they initially said. I wouldn't require this to be like a document like this affidavit is. That's just to answer both of your concerns, and that's what I sided with.
If it were presented to the city clerk, if they walked in and they said, I'd like to present Exhibit 3 to you, that's why I defer to the city clerk. He may have knowledge, I don't know. I merely state that if it were presented individually by those people and not sought by, in other words, how did Denise and Carmen get to the attorneys for the mayor? Did they call them up and say,
This was submitted to the attorneys, not the city clerk's office?
I have no knowledge of this being submitted to
How
the
was
city
this
clerk?
submitted?
Well, if I can, are you done?
Yeah. Oh, well,
Yeah,
Okay.
I don't want to step on your questioning, I mean, it's fine. The only offer I would make it to all here is that on, let me read from the document. On September 4th, the day after what you're calling certification, I'm calling verification, both, just my memory, just one second. Yes, both Denise Burgos and Carmen Ferreira, also known as Carmen Burgos, appeared in the election division and submitted this document. And both indicated and acknowledged that that was their signature to me, asking to be withdrawn, draw their names from the I'll call it the verification, or the affidavit, we'll say. Asked me what to do, and I said, I cannot advise you what to do. All I can tell you is you've signed an affidavit, and that was the extent of my conversation with them, and suggested that Mr. Tabit represented the mayor, and Mr. Farah represented the foundation, and that was, again, the end of my conversation with them. But I point out directly that this was after the verification, distinctly after the verifications. I think it was about 4, probably 3:30. The timestamp is on my document in the office. And I would leave it at that. I mean, there's nothing much more to it. It was uneventful. I could not tell them, and they were asking, do we, is our name withdrawn? I said, I can't answer that.
Mr. Maloney, may I? And I
By all
apologize, I know,
means,
Well,
that's all I have.
You set the ground rules.
right,
The two of you decided that one of you would present on objections.
That's
And
fine.
now, on this objection, we have two lawyers speaking.
that's why I asked
Okay.
for leave to do so, but certainly I don't want to step on anyone's toes if it's...
Let them go.
Okay. I understand what Mr. Maloney said about verification, but the bottom line is that the Board of Registrars did meet that evening, and they took a vote, and that's, you can call it whatever you want, that's a certification. And what we are suggesting is that prior to
Wait a minute,
that...
Oh, okay,
that's a
Wait, wait, wait,
determination
please,
up to the
please.
board ultimately, isn't it?
Please, let him argue his point.
My only
If you
point
wanna-
is
But you're
prior-
interrupting him, let him
I don't
speak,
want to
please.
interrupt.
My only point is, prior to that vote of the board, and that was the only vote that was taken by the board, I know that the clerk's office through Mr. Rodriguez verified the affidavits, but the vote, there was only one vote, and that was taken by this board, and I would suggest, I'm going to characterize that as certification. We may differ on that. Prior to that vote, these documents were submitted. And I suggest to you, it wouldn't matter if we called them and asked them to come into our office and sign. We didn't. But they went out and solicited signatures. We can solicit signatures. We can solicit support. But I have another suggestion as well. Taking into account Mr. Farah's concerns, and obviously they're legitimate, Mr. Newman had bypassed one of the paragraphs and said he was going to come back to it. The reason is because we anticipate asking this board for subpoenas. So I suggest that as to these two, we hold those or that motion in abeyance, and we subpoena the two individuals in themselves.
Well, gentlemen, I could have suggested the same thing to Attorney Farrer, but as you know, one of the things I suggested to everyone is, if you want subpoenas, to deal with it before you come here today, so that we're not...
Actually, if I have to disagree, Mr. Boddy, what you said was, I want to be prepared to have a substantive hearing. It's now 9:15. We've gone through about 3 or 4 of these. I would suggest that's substantive. The idea that we are somehow going to finish all of this in one evening, I think is a pipe dream. But perhaps we can get there. But nonetheless, to get these objections in, to have a substantive hearing, and then at the same time to request subpoenas that would be issued to potential witnesses and have them in all within that very short time frame, I think is a bit much to ask for. And I've been in contact with the city attorney's office, and I was very clear about our intent to have a substantive hearing tonight, which I think we're all having. But that doesn't mean that we waive any other rights that we might have to present evidence. And so that's the only suggestion that I make.
Through the chairman, do you have summonses, subpoenas, or something prepared for signature tonight?
We cannot issue those summonses or subpoenas. They have to come from this board.
Do you
Now, if
have
this
them
were a
in-
court in Massachusetts, I would have the ability to draft those subpoenas, sign them myself. These subpoenas, and I take your lead, since you are the city attorney, Mr. Boddy, but I don't think that I can draft and issue subpoenas for the city of Lawrence or for the Board of Registrars. If I'm mistaken, I'll spend all night drafting
You
them.
can draft them for a court, but you can't draft them for a board?
No, I draft
In
and
any
sign
event,
them.
I understand your point. I'm not going to press the issue, but I just, again... Well, okay. I guess, I don't hear anybody else chiming in, so I've got a couple comments. One of my concerns, we have a little bit of, got a little bit of variation, I'll call it, in this particular individual, Carmen Ferreira. She is apparently married, her maiden name was Burgos. When I look at her driver's license and I look at the signature on the voter registration card, those signatures compare well. When I look at the signature on this, it's different, but I have to understand that she appeared in front of the clerk and signed it in front of the clerk. So she's got 2 signatures, I assume. But what you're asking us to do, and I have a little issue with it, is you're asking us to take a document that's not an affidavit and isn't even notarized and use that to withdraw an affidavit.
Let me suggest, I'm sorry, I apologize, yes.
Having said that, however, I've got some issues with it, but having said that, I'm at this point prepared to make a motion. And I think that the motion, I'm going to say for clarity and procedure, I'm going to make an initial motion, and that is that the objection to let me just, if I can just pull out your actual objection, let's see. Yeah, I'm looking at it. I'm going to move that your objection that affidavit 117 not be counted be sustained.
Just one second.
117.
I have a very quick question. Was, and it may be moot, was, as paragraph 41 suggests, was her request for withdrawal filed with the Board of Registrars prior to the certifying of the affidavits? Does anybody know that? It's so close in time, I don't know.
Well, from what I understand from having heard tonight, sounds as though the withdrawal was requested after an initial run-through of the names, but before the Board of Registrars had met. The problem that we have here, of course, is that one side on this equation believes that a certification process is mandated, and the other side says, no, it's not, doesn't amount to that. So is it a certification or is it not? I guess the court feels that it is a certification. And if that's the case, and it is a certification, then necessarily a certification would require a vote. And so the court has said that it's a certification that's required, that requires a meeting of the Board of Registrars and a vote. And so since it was received before that, I guess, if you're of that mindset, it was received prior. But irrespective of that, that's my motion if somebody wishes to second.
The foundation,
My motion if nobody wants to second.
we have no objection to their names being, excuse me, their affidavits being removed. We accept completely the explanation
still
of the
requires
city
a vote.
clerk.
I'm gonna second that.
Got a motion made and seconded. The motion is to sustain objection number 41.
Actually, it's paragraph 41, not.
Paragraph 41,
Again.
paragraph 41 is stated in the objection. How's that? Okay. All in favor, say aye.
Aye.
Aye. All opposed, say no. Nobody's saying no. Everybody's unanimous. The objection is sustained.
I make a motion to sustain the objection that is contained in paragraph 42 of the objections filed by the mayor.
We have no objection, thank you.
Number 42, paragraph 42, excuse me. The motion is to sustain the objection in paragraph 42. Is there a second?
I second that.
Seconded by Pereira.
Pereira.
Getting there. All in favor indicate by saying aye. Aye. Motion is approved. Anybody opposed? None opposed.
Thank you for allowing me to speak out of turn, although be quiet until it's my turn again.
Thank you.
Not likely.
Not gonna be able to live with him. He's the only one that won anything tonight. I'm gonna do. Number 35 to begin with.
Takes care of that.
I'm going to do the category called signatures of non-registered voters, paragraphs 35 through 40. The first one is affidavit number 19, which was signed by former Councilor Onita. I asked the board to take judicial note that she resigned from her seat from city council because she was moving out of the city. She is therefore no longer a registered voter in Lawrence and is not eligible to sign. I think there were press reports, my understanding is press reports that she stated that she could sign it because she could vote for 6 months after she moved. However, that's not correct. She can vote in national and state elections for 6 months after moving if she moves within the state. If she moves out of state, she can't even do that. But she cannot vote in city elections, so she's not a registered voter. And I move that her affidavit not be counted.
Which number is that?
35.
35? Thank you.
It's paragraph 35, it's affidavit number 19 on the chalk.
Gotcha. Got it.
That's all I have on that one.
I would just like a citation to the statute that suggests someone who moves out of a voting district is prohibited from voting in municipal elections. I'm throwing that to Mr. Newman.
The statute, you're saying that the statute says if you remove yourself from the municipality, you are no longer able to vote in the municipal election?
That's what Mr. Newman is suggesting. I'm asking him for a statute that he can,
Oh, I'm sorry.
I need
understand.
help. Thank you.
That's what I am saying. And bear with me. Mass General Laws, Chapter 51, Section 1. At the end of that, it's qualifications for voters. No person otherwise qualified to vote for national or state officers shall, be reason of a change of residence within the Commonwealth, be disqualified for voting for such offices in the city or town from which he has removed his residence until the expiration of 6 months from such removal. There is no exemption for city elections, so they're not eligible if they move out of the city to vote in a city election in that 6-month grace period that they have for national and state elections. 51-1.
What was the date that Councilor Aquino signed the affidavit? We know when it was filed, but we don't know when these were circulated for signature.
I believe she signed it on, she did September 1st.
Might be helpful, but I'll rely on the clerk.
Well, I certainly have a good question. And to Mr. Newman, you state, and to the extent of the rules of evidence may or may not apply to this proceeding, you state that the affiant announced that she had moved from the district or moved out of Lawrence. You state that this is confirmed by media. You state that it's as if it were true. Is that correct?
I am not relying on the media. I'm asking the board to take judicial notice of the fact that she filed a letter with the city clerk resigning her seat. So
When was that filed?
My memory of the letter is a resignation letter. I don't recall, and I defer certainly to someone who might have better memory of what the letter contains. But my memory is that the letter is a resignation letter. But in any event,
there were, I mean, my understanding is there was extensive media and
the media wouldn't add anything.
they would never get anything wrong, you know that, right?
No, and they wouldn't add anything either.
Again, I didn't think it would be necessary, but if we're issuing subpoenas, we could certainly subpoena the former counselor in. I don't think it's
Want to
necessary.
get a subpoena now, okay.
No, I'm just saying that if
Would it
you
be-
do
I
not
just-
take
I wanna
judicial
look at the
notice.
Wouldn't it be
document.
extraterritorial if she's in New Hampshire?
Sure, we can serve the Secretary of State up there and have it drug into the proceeding.
I don't know if they have
was just thinking of
extradition.
looking at the document myself, but my real question is, and maybe it's more rhetorical, because I have the reverberation of, an election coming up with 500 people calling me up and saying, Dennis Newman, hey, guess what? He moved out. Let me send you a letter.
A little bit different,
Well-
I
In
think.
an affidavit form.
One of the,
I think
one of
it's a
the
little different. And
I
again,
think hearsay is hearsay, but
Well, I'll tell you, I think you have the burden in this instance. One of the questions that I have is, she may have resigned as a result of removing herself from the jurisdiction, but when was the physical move? You can register a child in a school system in anticipation of your move, in anticipation of the start of the school year, even though you may not, and I just don't know the answer to that. So I'm not sure that you've sustained a burden. I'm not sure you haven't either. I'm just throwing this out for discussion. I'm not sure you've sustained the burden with judicial notice. Of course, we have a letter, and we don't know what the letter says either. The letter may, in fact, state on such and such a date, I moved or am moving. So if you'd like to, I suppose, through the chair, if you'd like to, consider some sort of a subpoena, summons, or what have you in that regard, might be appropriate, but.
We can do that.
So procedurally, how are we gonna handle this, Mr. Newman? How are we gonna handle this where you've already presented the objection? You're going to withdraw it, ask us to table it, continue it, or something? Or how are we going to dispose of this on the record in such a fashion that we all understand what we're doing?
I think tabling it, is again, I don't believe we're gonna finish the whole hearing tonight. Table it for, the time when we meet again.
I have a question for Mr. Newman. We in this city have voters that presently live in the Dominican Republic. And they're registered voters. How does that differ from one voter moving to New Hampshire in this narrow window of time being disqualified?
Well, I think that the counselor answered that question by if she didn't think it was any different, she may not have resigned her seat. I don't know.
Well, it's one thing to serve as a city councilor. We're talking about being a registered voter. The being a city councilor is not the test. Is she a registered voter? She just moved.
Well, I think that your hypothetical is that if somebody has a residence here and they spend time in the Dominican Republic, is different than if they leave here and then establish residence in the Dominican Republic.
Thank you.
Someone can leave the state for a period of time and still not lose their residency.
What is that time?
It's not defined, but it's intent to come back here and then have to keep some sort of residency here, I would believe.
I believe it's 6 months too. Do you have any knowledge, Mr. Maloney?
Well, I think there are two things at play here, and I think number one is what the city attorney and I touched upon, is what I touched upon was hearsay, and the hearsay presentment, which the city attorney suggested be solved by subpoena, which I find entirely unnecessary. You came here knowing that you're going to present these. I am quite ready to present a motion to overturn the objection based upon your presentment, but now you're asking for more time. I don't know. That's the first thing. The second thing is residents. As counsel, you both know, and city attorney will certainly agree, that residents, there are a number of factors. One of them is time. One of them is point of breaking off to determine residence. And quite frankly, I agree with the city attorney that you've not met your burden in regard to this objection. And now you want to back off and say, well, let's just subpoena somebody in and disrupt them and bring them in. I don't know. I'm tossed.
Obviously, you're agreeing with me, and I have no problem with your agreement, but on the other hand, that's fine for you to agree with me, but on the other hand, council has requested that it be tabled. So, I think,
Most respect, he's not on the board. He doesn't make a motion, but he's asking.
no, he's requested it be tabled.
I didn't hear a motion yet.
No?
Go ahead.
I motion that it be tabled.
I'd like to be heard just a little bit. if I could. And I'm really very cognizant of the time and the magnificent effort of this board, not just tonight, but in the, 2.5 months, I guess, or almost 2 months. The burden is on the mayor's lawyers to make their case. They have had ample time to make their case. They have had ample time to bring in witnesses and not present hearsay, not present their best argument. Just, they should have brought in this lady, they could have issued subpoenas from this board, and it's too little too late. I would ask you not to sustain this objection. There is absolutely no evidence presented to this board tonight of her residency anywhere. And we cannot rely respectfully on media reports as a basis of evidence. Thank you.
What's your motion? Motion on the table? It supersedes everything else. Well, I understand.
I have no idea what you just said.
I know, I'm sorry.
Is her motion on the table?
I thought she wanted to make him, affirm
Did
her
she
motion.
move or
You
not?
don't know.
So I motion it to be tabled.
Right, that's what I was asking, do you want to affirm? Okay. Seconded by Attorney Bellotti. All in favor of the motion on the table, say aye.
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 No. Roll call. Registrar Pereira? How was that? Getting better. Getting better, thank you.
Present? Yes?
I vote no. Attorney Bellotti?
Yes.
And Chair.
Yes.
3-1. Motion carries. Item is tabled. Next, I guess.
The next two objections that I'm going to address are paragraph 36, affidavit 53, and paragraph 38, affidavit 165. And 53 is an affidavit of Emil. Rosado. And 165 is Rosa Castillo.
Castillo.
And we ran
So 36.
Thought they were. My apologies. Okay, there's 165, Rosa. And 53. Okay, homework assignment is to put these in order. I thought they were, my apologies.
I wanted you to have one piece of paper.
I should get a little extra credit just for making the copy this long.
New size, new shape.
I didn't get one of these.
Oh my goodness, thank you.
There's only one of those, so
We ran a match through the National Change of Address service,
Additional change of that.
and I gave the ledger one copy. I don't think you all need a copy because it's pretty thick. But bottom line is, these two individuals have moved out of the city of, have moved their voting address, or their address. Emil has moved to Methuen, and Rosa has changed it to a post office box. And as you know, you can't be registered from a post office box. So that I believe that those two should not have been counted and should be removed from, counted as affidavits.
Do you have their date of birth on there? Do you have their date of birth on the NCOA report? It's undeniable. For the edification of the board, NCOA, National Change of Address, is a postal service support service. We used to use it. We no longer use it in voting systems, but I think Mr. Newman remembers those days.
I object to the introduction of what is now Exhibit 4, am I correct? I object to it.
Okay.
It's,
You bring up a good point. I would like to know what, when you have an opportunity, Mr. Clerk, I'd like to know what the exhibit numbers are. I know we were given at one point with regard to Burgos and Ferreira, we were given a number of documents
This
that
is
were marked
actually
for
should
identification
be-
purposes. I don't know if those have been entered as exhibits.
Well, I just progressively go on as ID,
Right.
exhibit, et cetera.
But-
So I have
but
three.
Have we accepted them as exhibits, other than for identification purposes?
Nobody's moved to adopt them as exhibits, nor has the board. I have number 3 for ID. I have number 4 for ID, number 5 for ID, and this would be number 6 for ID right now.
this is 6.
This is exhibit number 6,
So they're not in evidence?
just for identification on those documents.
Again, it's the same objection that I made in the last paragraph objection. This is hearsay. We've got to have some basis. We have to have some legal basis that is admissible in a court somewhere in this Commonwealth for the evidence that's presented here tonight. We do not have witnesses who can stand before you and take an oath. We do not have affidavits. We don't have notarized letters. We just have Mr. Newman's assertion that this long document and some internet company is evidence. It isn't evidence. It's hearsay, and in law school, we used to call it totem pole hearsay. It should absolutely not be considered by this board. And I urge you strongly to reject sustaining those 2 paragraphs.
Well, let me just ask this question. Are you suggesting that the standard here is that hearsay is not able to be introduced into evidence? Because I think that the standard in the CMR is not one of whether it's hearsay, but whether it is a document upon which a reasonable person would make serious decisions.
I think in your opening to all of us here tonight, we talked about a reasonableness standard. It is reasonable to object to, particularly when the burden falls on the mayor's lawyers. It's reasonable to object to something that has no indicia of accuracy at all whatsoever. He should have, could have, and didn't bring in these people. He could have subpoenaed them. This is now running into a pattern of allegations without any support. It's a pattern of the lack of any evidence, be it personal appearances or the like. It really is it's not appropriate to address these things.
Well, this is a change of address form, this long sheet that you've provided to us, correct?
That's correct.
No, it's
And
not. It's a report.
Well, it's a report
from a company.
from a company. But it doesn't necessarily mean, in the case of Rosa Castillo, it doesn't necessarily mean a change of residence, does it?
Not clear.
Elections used to use the national change of address in part of its elections process of determining addresses, but as a secondary measure. It was abandoned, I want to say about 6, 7 years ago because of its unreliability, number one. But it was only used to try to contact people. In fact, we used it as early as 2006 to try to reach at different addresses where people might be. The reports are never determinative and never relied upon as evidence of actually being there. I have serious questions as to the substance that is being presented for, or the proposition that's being presented for, when the council knows full well that the actual evidence is the CVR and a statewide view under the standard. Even in certification, it'd be the CVR standard that would apply, not the secondary source.
What's DPV?
That's a good one. Deprived.
Where's that?
In the middle, roughly the middle of the page, the DPV indicator, DPV validate or validated.
Delivery point. There's no code.
What's a record type S versus a record type P? If DPV footnote,
they're
DPV
on-
CMRA.
They're all right here.
Oh, you have it. I didn't have that. Yeah,
DVP is delivery point validated.
he's got a code.
Oh, it's in that?
Yeah. He's got a code.
What's record type S and record type P? Do you see that?
Yeah, let me find it really quick here. Record type S. Record type S, street record. Record type P,
Post office.
post office box.
Okay.
Can't have a post office box.
And it says in the address line, it is.
When did Edemil Rosado sign his affidavit?
Believe,
August 31st, I think. So,
August 31st.
August 31st.
August 31st?
Found that one. Yeah, all right.
And so the move effective date on the change of address is September 1st?
That's correct, but prior to it either being submitted or...
I'd object to that being characterized as a move effective date. It's an alternative address. I mean, understanding what the NCOA is, it provides multiple addresses for singular postal service clients. It may, in fact, it may be a multiple location. It's not necessarily a move.
The person affirmatively filed with the post office a change of address form. That's what this picks up on. So
You
this
use the
vote
word
in
artfully, I
particular-
agree. You use the word very artfully, as a change of address. That's what the company is called. But its real purpose is to provide postal service clients with multiple addresses if they desire to use them.
But it
That's
also-
one of the purposes.
That's correct, but also, it captures when you file with the post office a change of address form, that information is captured by this organization. So, this gentleman filed a change of address form, that his address was moving to Methuen, and, and again, he filed it on September, the file date is on record as not, September 1st, signed the affidavit on August 31st. However, it's prior to either the clerk's action initially or the board certification subsequent to that. So the time that it was to be verified, he was no longer a resident in Lawrence.
I find it hard that you conclude that. I find it quite strained, even with the evidence that you're presenting. I just, you jump from, you make a leap of faith that this person's primary location of their residence by this document is somehow changed without offering any other evidence. I'm just curious, that's all. I mean, it's interesting, it's interesting. But again, I would caution the board and certainly advise the city attorney that the NCOA was never deemed anything reliable to use on confirmation notices, was never anything deemed reliable to change anybody's address on the CVR, was never deemed reliable and therefore never used. It is used as a secondary source, just to determine, to find people in an effort to locate them. And sometimes we do and sometimes we don't, but I don't know. I mean, it's your case.
I get you.
In case you weren't aware.
In case you weren't aware. Thanks, Charles.
I move that we table both paragraph 36 and paragraph 38 to provide further evidence of a move by those individuals.
Shame on the mayor for producing this type of evidence to this board tonight. This is not to be tabled. This is once again nothing. There is no evidence here that you can rely upon, even a reasonable person can rely upon this, as evidence that they've moved out of the city with any intent to change their voting address. This reminds me of my late parents who used to go every year to Florida, and they would file a change of address form with the U.S. Postal Service. It should not be tabled, you should vote on it, and it absolutely should not be sustained. Thank you.
Again, just in passing, the pattern I'm beginning to see, and I say this to the board and to the city attorney, is that whenever the evidence doesn't suit what the proposition is, it's a move to table. Let's get more evidence. The city attorney seems to concur, and no offense, Charles, that maybe we should table these things in order to get more evidence later on down the road, for fear that maybe, maybe the court won't like it. I don't know. We're here now. This was presented by the petitioners for a decision. Something, and every case that, and I suggest to this board as we go down each one of these, every case that we run across, geez, if they can't sustain their burden, let's just table the damn thing and let's go on. Excuse my French. Let's just table the thing and move on. And we'll bring something more definitive. We'll subpoena somebody, or we'll research the CVR. I thought that's what we were here to do, but anyway, I digress. And by way of digression, I move we overrule these two objections as insufficient on the evidence that's been presented. Put that in the form of a motion.
Is there a,
Do these separately? Or,
Sure,
Okay.
I'll ask it on number 36.
was there a motion to table?
No,
Okay.
so on number 36?
I'm motioning to overrule number 36.
I disapprove.
No second? Fails for a second.
On number 36, I actually motion to table it.
Motion on the table. Is there a second?
I can't see. No, I can't see.
No second. Fails. We're at an impasse. Given that there are 30,
I'll move to overrule.
I renew my motion to overrule number 36. Second? All in favor? Say aye.
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 All opposed? No?
Here,
No? Oh, yes.
I oppose, yes.
Opposed, okay, I'm sorry. Roll call. City Attorney, Lottie.
Yes.
I vote yes. Registrar Pereira, thank you. No? Chair.
Yes.
Vote yes. Number 36 is overruled. I present a motion to overrule number 38.
I second that.
All in favor, say aye. Aye. All in favor, all opposed, say no, and nobody answering no. The number 38 is overruled. Mr. Newman?
Objection, paragraph number 37, 113. It's the signature of the affidavit of Maximilian Gino. I don't believe that there's no voter registration information on the voter list, so he's not a registered voter and should not have been counted. I'd ask the board to check their records. It was certified, but again, going through the voter file, which was provided by the city. As of July 15th, he was not. If city's records verify that he in fact registered after that, then we would withdraw our objection. But we believe that he is not a registered voter and should not have been counted.
Fair.
13.
This is paragraph 37, and the grounds are exactly the same grounds as in paragraph 36 and paragraph 38. They have not preserved their right to question whether or not there's a voter registration card with respect to Affiant 113, Maximilian Janile. So I would suggest that it's overruled. Thank you.
13.
Reyes.
Mr. Reyes, how do you confirm someone as a registered voter? By what process?
I look in the CVR, check them by name and address, and if they match up, it's considered as, further, certification.
And what is that?
The CVR is a central voter registry that the state check all the voters.
When does the voter registration card come into play?
It comes into play once we receive it by mail by the voter, or we could come in person and register, or even by the RMV also too.
If you use the CVR to your satisfaction, do you use the voter registration card?
Well, every voter registration, we have to enter into the CVR.
All right, thank you.
I have a question for Mr. Newman. I noticed in your presentation to uphold your objection, you stated that the voter, and maybe I got it wrong, did not appear on the voting list that you provided on the flash
That's correct.
of July 15th.
That's correct.
So if the voter was registered after that date, that voter would be valid, is that right?
I believe that is correct.
And the reason I ask, I'm not trying to pull any punches here, I don't, is that I'm looking at the review, what you call certification, from Mr. Tabitz, by Mr. Reyes, is that he saw it on the CVR. And that there is a registration card dating registration in 2009. I'm just curious. Huh. I mean, unless he was deleted, moved, or changed registration in another city and then re-registered, by the time he got back here on August 31st, that registration would have been current and valid throughout. That's the evidence I'm looking at.
What I'm suggesting is that the voter file on July 15th did not have this gentleman listed, that in fact you did provide a voter registration card at our request, and he was registered, I think the card said 2009, is that what you said?
That's what the card says, yeah.
So I am suggesting that it's not a newly registered person because he registered prior to the petitions coming up 6 years ago, and he's currently not on the list that I could find. So what I would ask is the board look at the records, and if they
We did.
comfortable,
We did. Here's the record. Here's the record as of September 2nd, not that one, this one. That's when the review, what Mr. Tabby calls certification, was done. And the voter appeared on the CVR as a registered voter. That's what, and Mr. Reyes is here to testify, and he just did, that's what he did. Maybe not in this instance, but in a general matter. I find, as I said in the beginning, that this is unreliable. Number one, I don't know where you got it. Number two, I don't know what you focus on July 15th for. Maybe that's the date.
that was the date of that voter file.
The date of this file, and it changes daily, as you know. And as you know, too, it is subject to error, and I certainly would concede that. This is a human process. There are errors, and the error, I say, is here, not here. So I assume you're going to ask us to continue the matter to get more records.
That's correct. What I'm suggesting is that of all of the, and again, we've looked at these very closely, as you can imagine, and of all of the ones that we have gone, the different objections, we have different objections on different grounds that we're going through. On this particular one, we couldn't find it. So we're respectfully requesting that on this one only, that we check the records again, and if
We
Mr.
found
Reyes
it.
said, in fact, he is still registered here, then we would withdraw the,
We found it on two occasions. We found it on September 2nd, and we found it again, probably about, 2 weeks later? Found the original registration card that you asked for. Now you want us to continue this, table it, so we can get more information?
I'm sorry, the second review, I'm sorry, I'm not,
Not a second review, you asked us to get records of the voter's registration. This one, not in
Correct.
particular.
yep.
I think we got a number of them. This one was found.
if this gentleman had moved out of the city or had re-registered somewhere else, you would still get a card for him because it was registered in 2009.
True.
So he could be, he could have moved and would no longer be a registered voter here and be removed from the list.
But
My
that's your
request is-
burden, not mine.
Finish, please.
I'm sorry. I have
My request is,
a habit of doing that.
it sounds like my wife.
I could never be so good-looking.
Who said that? I know, really.
You do realize there's a permanent record of this we can send to her.
Be careful what you say.
I know.
Anyway, I'm sorry, I didn't mean to interrupt.
Again, of all of the records that we looked at, this is the one that we feel that we would respectfully request that the board check their records again, and if they find it, then we would withdraw this objection, and if they don't, then we would continue the objection and ask that it be removed.
The only comment I have is, I think that we've been at this a few hours now. Every time we run into a lack of or sufficiency of evidence before the board, there's always a request, is followed by a request that we continue to search, keep searching. Keep searching. Now, I mean, I don't know.
You know, I do think in this instance, again, the burden is upon you. You've brought forth some issues. What you've said was that you found no registration. We found a registration. I've seen it in our package, and you don't have it. You should obviously get a copy of that too.
I do have a copy of that registration.
Okay. So, we have it. Again, having now found a registration, the burden shifts to you to show that he moved or is otherwise not registered, as I see it.
We believe that we have an official voting record on the disc of the registered voters as of July 15th of this year, and that our search, my search of that particular record, going by first name, last name, several times, did not come up with a person registered in that name in the city. And therefore, I believe that it is an error that it was certified or deemed acceptable and then certified. Regardless of the fact that he was once registered, we're not disputing that. We're just disputing the fact that at the time that the signature was obtained on the affidavit and it was certified, it was checked by the clerk's office, by the election division, and then certified by the board that he was not a registered voter in the city of Lawrence and his name should not have been counted. The request is fairly straightforward. I believe that the search can be done, if you wanted to, we could take a brief recess and Mr. Reyes could search it, and if he comes back and says, I was right, Newman's wrong, we will withdraw the objection.
Sounds like a plan,
All right?
See, why not?
but I don't, I guess, Mr. Farrow, I'm sorry, Mr. Farrow.
That's okay. I know that twice this gentleman was vetted by the Board of Registrars. I am told also that he has signed the nomination papers of Mr. Green in his quest to become a
I'm
city
sorry,
council.
could you say it again?
Yes. I've been told that he has signed the nomination papers of Mr. Green, who's here today, in Mr. Green's quest to become a member of the city council. I know I'm starting to sound like a broken record. It's gone on too much tonight. These are just allegations without any evidence behind them. Twice, the Board of Registrars has certified that this man is a registered voter, and I think this all should be stricken. This objection should be stricken as well. There's no evidence here that he's not a registered voter. There is evidence that he has been certified by the Board of Registrars. Thank you.
If the board's willing, I'm certainly agreeable to allow Mr. Reyes to certify, or to check the CVR.
I'll move to table.
I wouldn't table it. I'd move on, or table it in the interim for a report this evening.
It's 113.
Sure. You table your motion.
Well, so you asked me to amend it.
Oh, I'm sorry. What, is it 53?
It's number 37, and
Oh,
it's
give me that one back.
voter
Give me that one back.
113.
I'm sorry.
Yeah, 113.
53, 113, thank you. There's a motion on the table, motion on the table to table.
I'll withdraw the motion.
I thought I had it right away. Give me a second, sorry.
Let me help him. I know,
113.
talk to him, he might
I
snap.
just had it too, I showed it to you. See what you did?
It's late.
I can't find, you have it there, Donza? Oh, here we go, I got it,
Because I never found it.
I got it. There it is. Yep.
I'd like to hear a motion for a 5-minute recess.
5-minute recess,
Thank you.
1 second, Aldonza, Ms. Pereira. Pereira.
Yes, very much so.
Thank you. All in favor, aye.
Aye.
5-minute recess,
Recess.
take a break.
5-minute recess.
Resume. Motion to resume session second. Alonso?
I second
All in
that.
favor, say aye.
Aye.
Oh, they're not in yet?
Call them in, I wanna go home. Mr. Maloney? Mr. Maloney, when do we end?
We're gonna end, Nick, tell the plan if it's okay with you.
They're gonna do 37, and then let them do the last two in the block, then we'll call it a night.
Okay, thank you.
Think about, what, two things, our next meeting. I'm thinking Saturday, I'm posted for Saturday, if you can't, let me know, then I'm gonna continue at that point, you know, can't do that. And, can't meet this time, and we ain't got nothing to do. We'll talk about this. Yeah, oh yeah, the whole thing's gone.
I apologize.
No need to apologize.
So is my husband. Saturday
Well,
is
after
good
I
for me.
called your private line and I got the number.
The question isn't whether she was calling you, it was what she was calling you.
All right, clerk, what do we have?
Mr. Reyes ran the CVR, and the registration date for Mr.,
Maximiliano Genoa.
thank you, July 27th, 2015.
Okay, we withdraw that objection then? July 27th?
I'm gonna mark this as Exhibit 7. Joint exhibit, is that okay?
It's okay with me.
Yeah.
So, for the record, paragraph 37,
You withdraw number 37?
affidavit 113, we withdraw that objection. There are
Next.
There are three other affidavits, number 30, wait a minute.
I think there are only two, no?
39 and
Two
40.
more, I'm sorry, number
40.
4 and number 70, paragraph 39 and 40. Our objections is that the affiants are not registered at the address that they are listed on the affidavit and should not be counted.
Number 4 and number 70. I'm just double checking my list. Then I want to pull the record. Is number 4.
Four. It's four.
You want to address them jointly, Attorney Newman?
Can he address them jointly? Shouldn't we be doing it individually?
Yeah, I guess the board wants to do them individually, Mr. Newman, so we'll deal with number 39 first. That's affidavit number 4. Is there a rebuttal?
If I could,
Oh, I'm sorry, I didn't know you weren't done.
paragraph 40, affidavit 70,
We're looking at number 39 first. We're going to do one at a time.
okay.
Please.
All right, 4, there, it's not, I was going to withdraw number 40, but,
Oh, let's go right to 40 then.
what?
Let's go right to 40. The board agrees, I think.
I'd like to withdraw number 40, affidavit number 70. 39, the affiant is not registered at the address that she signed. Should not be counted.
Rebuttal? Mr. Farah?
I don't think, I don't think it makes a difference. I don't know what evidence, I don't see anything in front of me to suggest that she is registered at one address or another. Is there any evidence, Mr. Newman?
Well, there is some. Your original affidavit, I'm sorry, original voter registration, and I have copies, does not have that address. And also on the July 15th, July 15th, voter registration has a different address.
You got to speak in the microphone when you speak, please.
I ask you, you repeat what you said to the microphone?
Goes back to the point you were suggesting. If there's a certification, she's updating her address.
The affidavit, as it must, shows the current address
No question.
that she had on the day of signing the affidavit. This card is dated,
14. She may have moved. We sent her.
October 15th, 2014. It's a year ago. It's insignificant.
That's what that-
She, in her affidavit, as people change their addresses all the time and can do so, she lists her address as 4 Greenwood Street. And it doesn't make a difference.
If I may address the board, the evidence on 4B that was developed, it's kind of a mixed match here of what's being presented to you. There is, first of all, verification from Mr. Reyes, what Mr. Tabby likes to call certification, and I'll cede to that. But Mr. Reyes found her on the CVR at 4 Greenwood. That's what that check mark means. He's here, subject to examination if you would like. And the signature on the original signature card. What council has asked us to provide is any signature card we can find. She happens to have a signature card dating back to 2014, a year ago, at a different address. And now utilizing that argument that the different address, for some reason, does not match up, when in fact, we're likely to find that she re-registered if we pull the CVR records again. And I think it's somewhat, it's an artful argument. I think it's presented well. I think council is well aware of what I'm suggesting. She is registered at the address at 4 Greenwood, as far as the records that I can tell. Council?
We'd like to withdraw 39, affidavit 7. Clerk is very persuasive.
Before you proceed, I think the chair would like to be heard at this point.
Could
Oh, I'm
counsel-
sorry.
Co-counsel say a word before?
Please, yeah.
Oh, yeah,
Come
sure.
forward.
Thank you very much again. And I apologize, but I'll be brief. I know how hard this board has worked, and I know how seriously you've taken this process. All of our objections, and I know there'll be more forthcoming, were all done and have been done in good faith after substantial research. That doesn't mean that we are always right, and that mistakes aren't made that can't be corrected. I know that there are several people here who have addressed issues of their own signatures, and I don't know if they're going to have an opportunity to come back here the next time we meet, so I would like to go through and withdraw several of our objections so that people are satisfied that I'm doing what I told them that I would do, and that we can speed up the process a little bit and obviously lend, not that it needs more credibility, but even more credibility to the process. If you'd allow me to withdraw several of our objections.
I have no objection to that, Mr. Tabbitt. You gave them your word. You may proceed.
We would like to object, or withdraw objection number 5 to affidavit number 54.
Okay. Again, for the record, we have paragraphs and we have objections.
Okay.
What I see as headings are objections and then paragraphs underneath them. So.
I'll do the paragraphs.
So that we make sure that
Certainly.
what is being withdrawn is in fact what we're withdrawing. Can
Certainly.
we just address it as paragraphs?
I will, I apologize.
No,
So
no.
Paragraph number 5, affidavit number 54.
Thank you.
objection is being withdrawn. Paragraph number 12, affidavit number 85. That objection is being withdrawn. Paragraph number 31, affidavit 174. That is being withdrawn. Paragraph number 32, affidavit 176. That is being withdrawn. And then if I could refer you to paragraph 44, this board has already ruled on those objections. You've overruled those objections in their entirety. However, there is a gentleman here who was affidavit number 127, who was very concerned and provided me proof of his registration, et cetera. I explained to that gentleman that you've already overruled our objection in any event, but I just bring it to the board's attention, and that's already been done. Thank you very much for your time, and I apologize for,
Is the gentleman at ease?
I believe so, yes.
You're sure?
Ladies and gentlemen, if my math is correct, and it's not my best suit, the mayor has now failed in his burden to eliminate or strike 100 or more voters. If you take these now recently conceded withdrawals, the mayor, in no mathematical calculation, can strike and get us below 100 voters. It's a little tricky to figure it out, but we've kind of figured this out.
Well, paragraph 43 remains.
It doesn't.
We haven't done it yet.
Oh, 43, I'm sorry, I thought we did.
Yeah.
Yeah.
Oh, you're right, right.
43 remains, and
20. There were only 20 affiants on number 43,
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13.
and we are at 134, having surrendered 2 of the affiants who have resigned or reneged on their affidavits. If you credited all of 43, which are 20 votes, you're still at 113. And we still meet our petition number, or our affiant number, to have this board issue the petitions. I think this argument is concluded. There's nothing else to do here. You need not address anything else.
May I? Thank you. I think, with all due respect, I think the calculations are wrong from Mr. Farrow. We have all of the ones.
I think the calculations are wrong, too.
Okay, I'm sorry.
It's all right. I know you're tired.
I have 2 ears, but I can only listen to one conversation.
So it's true, we haven't addressed 43, but there were also the first paragraph, the first body, which is signatures failing to match registration cards, 1 through,
40,
1 through 32.
32.
And some of those have been withdrawn, but when you add the 2 together, there's more than enough. Not to mention that at least one has been tabled.
Correct.
So, I think there's enough there.
Schedule it for Saturday.
Yeah, I got 51 still alive. I don't get it. 2, 3, 4, 7, 8, 9, 11, 12, 13, 14,
28.
17, 18, 19,
48
20,
total,
21, 22, 23,
right?
24, 25, 26, 27, 28.
What do you,
Plus 20, but they may overlap.
What, these two?
that we have to
29, 30.
no, out of the,
These two? Not these two.
Oh, okay. We haven't done those.
We haven't done those. So 30 plus the two tables,
And we haven't done 43.
and the 21, 30 plus 21. Yeah, it's still live.
Plus, there's an, the only argument that they're not still alive is that there's an overlap
That's correct.
on the 43. No, we're gonna continue.
I agree. Yeah, you agree? They're not at the number. I don't see it.
What is it?
They're not at their number.
Right, we just counted, right? Did you guys count? I counted 48.
Yep, the,
It appears from our calculations, Mr. Farah, that the numbers do not warrant concluding this proceeding just yet. And I don't mean just, and I don't mean yet either. I mean that just the numbers aren't there. I think
Continue.
even if they were,
You want to go
it
through
might
each
be
and every one?
calmer or better take, I think the city attorney will agree to kind of consider what's being suggested, look at it overnight, or overnight several times, and then conclude this proceeding.
we're gonna conclude this proceeding.
Mr. Chair, there's a couple of housekeeping measures I want to address. This proceeding is going to be suspended or continued, we'll say, I'm going to say continued. First thing is, I think the manner of subpoenaing as was being suggested earlier, and again, I think that the method was being suggested early on at some other proceeding. My memory is if you present subpoenas of people you want to appear, we'll authorize them and certainly send them out at your cost and expense to bring them forward, if that was my understanding anyway. And then we'll proceed on that basis. The other issue is glaring to me the date of the next meeting. Now, I have posted for tomorrow evening and posted it in time for Saturday as well. I'm told that the chairman cannot make it tomorrow evening whatsoever. He has an appointment that that certainly he cannot dispense with. We try to balance certainly our council, you guys, everybody else that wants to be here, and the public's ability to perceive this. I have scheduled for Saturday, I just throw that out, just to the board at this point. If the board wishes to conclude for Saturday to continue this, I'm suggesting 10 a.m., that we start this again at 10 a.m. That may not be enough time to subpoena people for the moving party here, the objectors. There may be other times in which we have to consider evidence of the subpoenas. Saturday at 10 a.m., is that agreeable? Council? Okay?
I have a problem with that.
I can't do it.
You can't do it? Oh, I'm sorry, I got two of my board members
Oh,
here.
no, I could do it if the chairman
He's gonna
can.
do it. The chair.
Or if the chairman can't do it, then.
If the chairman can't do it. Not this weekend? So that's that. We can't operate the board certainly without the chairman, number one. Number two, or can we? I prefer not to.
Well, we certainly could, but I think that where we've commenced the hearing with 4 members, I think it's incumbent upon.
Yeah, I don't want to.
I feel more comfortable with the full complement of the board rather than, proceed without anyone that's here, short of an emergency or something else that happens. That being said, the next thing that I'm going to suggest is, I got 3 people in my election staff, and we are full tilt getting ready for an election. And I'll make no bones about it, and I'm gonna move and present to this board that we suspend until after the election is certified. You can object if you'd like, and you can file your objection, but I cannot do both effectively. And I've made that known to the council president, I've made that known to the city attorney, I've made that known. I'll be doing work, I am now to the point of exhaustion, doing both. And I want to make sure that that election is valid. And I want to make sure that election is not questionable. I also want to make sure that this proceeding is valid, and this proceeding is objectionable. And I say that most advisedly. The tasks that are attendant to running an election do not change because it's a off year. The focus and the work is just as difficult and just as hard. This requires full attention as well. I spent nothing less than a full day today, half a day yesterday on this alone, and to the sufferance of elections. Now, I don't want to be able to give anybody out there, fodder, who may be a candidate for election, a reason to question the election. And for that reason, seeing both as constitutional matters, I see the election as more pressing because it is more current, and it's going to happen within 10 days. This, we won't be done even if we met on Saturday, I suggest. I don't know that for certainty. You guys are suggesting, and I say you guys advisedly, the council is suggesting that we're reaching a point where it may be. I'm presenting a motion now to the board to suspend this matter until certification of the city election for 2015.
I respectfully request an
You're not a member
opportunity
of
to
the
be
board,
heard.
excuse me, I'll let you be heard, I think, or the board would want to hear from you, but I'll present the motion, I want to hear a second first, and then we'll take
I
comment.
second the motion.
Mr. Farah?
All right. You have worked very hard. Everybody is concerned about the rights of this foundation to present their petition under the city charter. We're already in violation of a court order, and I know you're working as hard as you can, and I got to tell you, I respect it. I think tonight satisfied me tremendously on the efforts of the mayor's attorneys, and quite frankly, on everything this board has done. But to wait 10 days is an absolutely unfair thing to do and probably an unconstitutional thing to do. There has been no evidence presented tonight. There has not been one witness. There hasn't been an expert witness. There hasn't been a witness with personal knowledge here tonight. So I respectfully request that you schedule this for Saturday, for Monday, but before, and we're very close. By my count, we're down to paragraph 43 of these objections. And if they can't meet the burden on 43, and by then the city registrar's office will have time to go check these cards. If they can't, this is over and you've got to issue the petitions. So I think you're down to one argument, which is 43. And we get to 43, and either those 20 names are duly registered voters or they're not. It probably is something that can be resolved tomorrow. And then either they meet their burden or they don't meet their burden, and if they don't, you've got to issue the petitions for the recall. We cannot wait till after the election.
Mr. Newman?
Take it then.
There's no, I disagree. There's no, first of all, I want to thank the board for their diligence and hard work. I know that's a long and torturous process. But I am comfortable with waiting till after the election. Saturday, we could not issue subpoenas and get people in by then. If it's,
Well, Saturday is out. I mean, the
All right.
chairman's already said he cannot make it Saturday. I posted them in the eventuality, because I have a 2-day posting requirement, as you know.
Got it.
I've toyed with the idea of Monday. I mean, I think the Personnel Committee is required to meet on appointments that will go by the boards if they don't meet Monday. I think we're pressed with other matters as well. The Personnel Committee is not meeting on Monday. I forget what committee it was meeting. Oh, it's the Ordinance Committee.
But do we have the requisite 48 hours to post?
No,
So,
so that's out.
it's a moot issue.
Tuesday, and again, each day that gets closer to the election, it drags my time. I start, I don't want to bore you with the details. I can tell you, just let me tell you this much, you wouldn't want to do it. But the fact of the matter is, every election that these guys run, I run. And I don't get into any office. But the fact of the matter is, it's my responsibility. And that responsibility, and I'm not going to be so definitive, may be in jeopardy if I devote split time to this. And I don't want to suggest that it is now. the staff is already feeling the pressure, and I didn't want to go out publicly without exploring the idea. I certainly disagree that we're in violation of any court order, first of all. Second of all, if we are, I'm sure that the door is open to you, Mr. Farah, to file an appearance at least, to get there and seek a citation and to get us back on track. And I'll give up every election work that I have to do just this, if that's your desire, and move toward that. But I cannot do both effectively. It's unreasonable, and it should not be allowed, even unless you want to volunteer and come in and do my work for me. But the fact of the matter is, we're close, and I don't disagree with that. I don't think we're in violation of order. I think not only this hearing, but the opinion of the board has been, number one, that we shouldn't even be here, number one, but we're proceeding because of the court order to address these issues. And I extend my apologies for having to work double duty. I'll work around the clock. As it is, I will, anyway, because of the election. And something will break, something will suffer. And I have 38,512 people who are depending upon electing representatives to their local government effectively and with confidence. And that will be done regardless.
As a kind of a solution, I'm looking at 43, which I think would be the next one on the agenda, but could we ask, not tonight, but tomorrow, can we ask the Board of Registrars to answer the question?
Board of Registrars is not available for tomorrow evening. The board chairman cannot meet.
Monday, just somebody come
Cannot
back
meet
to us.
on Saturday. Monday is out. We can't.
Well, under the statute,
It's not
somebody
posted.
under the statute, somebody can be appointed, as Mr. Reyes did.
Monday
and-
date is not posted, Mr. Farah.
No, let me finish, and I'll explain.
Oh,
All I'm
okay.
asking you to do is, if you look at 43, it just simply asks to match the signatures in the affiant's affidavits with voter registration cards. And I just think it's something that could be done at the leisure of the board, and that may be helpful to us. If you have
Are
someone...
you
to do it.
asking we address it now?
Yeah, yes.
I wasn't clear. You want to address it now? It's up to the board. I'm game.
Number 43.
43, no affidavit, no registration cards.
Well, I mean, what
And
is,
21. We did. We have the CVR report right here.
Okay.
I'm sorry, what just happened?
We're going to proceed with
We're going
paragraph
to proceed
43.
with number 43 and then continue this matter.
Continue tonight?
After number 43, we're going to address number 43. You have an objection?
I do have an objection because we're going to subpoena those folks.
Where are they?
They're not here, obviously. And I don't, I think that there was a motion on that someone made a motion to...
I withdraw my motion.
Okay. We would like the opportunity to subpoena these people in to the next meeting, whether it be Monday, but it couldn't be, obviously Saturday is out. I don't think that, this is a process which, I don't see the immediacy of trying to get it done in a a not fully vetted way, so that I think that the proponents, I think, are pushing so that they will have petitions filed in time of the election so they can collect signatures. I don't think that should be the determining factor for the board. I think it needs to be done in a way that is fair and effective. And if we're not able to subpoena people in, we will not have the opportunity to question them. We had requested voter registration cards. They were not found, so there's no evidence that they are registered, that we have been given to. And I think the best evidence is to subpoena these people in and ask them if they are in fact registered voters. And, you know, it's, as you said, the burden is our case.
Please continue.
Me?
Yes. There's a little bit of noise behind you.
So I would object to taking these up now. And if you're going to take them up, so I would object to that strongly. And I don't think that the board, and to reiterate the clerk's comments, I don't believe that you're in violation of the court order. You obviously are hearing, you started the hearing before October 16th. It's certainly not unconstitutional, so I think that those arguments are not sufficient. Thank you.
Whatever methodology that was used by the Board of Registrars to certify 136 of those signatures should be good enough to resolve the question of whether or not these people were registered voters at the time they signed the affidavit. Whatever system you used is fine. Their burden is to say that they're not registered voters. They're telling us that there are no voter registration cards, but how do they prove that? They've been certified by this board.
We know the system that we used to certify the affidavits, because we did so. But they certainly have the right to challenge in their objection in the way that they seem appropriate, and we should hear it.
I agree, and this is not a meeting that convened quickly. Again, this comes back to there's no evidence tonight to support anything here, and I'm just asking this board.
Then we can't continue tonight.
Well, but it's their burden to produce the evidence on these objections, so you can reject the objections.
It is.
They just, they come in with objections saying that something is wrong in your methodology. They're attacking you, and I'm saying, show me the pudding. I want to see it. And I haven't seen it tonight. So these are just allegations that mean nothing unless there's some evidence behind it to support it. I'm just asking for the evidence. And in the absence of evidence, I don't see how you can do anything but to strike them.
For the sake of argument, if I may, the 21 affidavits that were verified, were apparently verified, and obviously through the CVR, use of the CVR, appeared on the CVR, got there somehow. I can't find any registration cards. My staff can't find any registration cards. They looked hard, as you know. If that is not sufficient for them to carry them on the rolls, then they probably, it should not be on our registration rolls from a neutral standpoint. But the evidence that we do have is that they are registered.
If
and
I
they are
might,
qualified. Go ahead.
if I might, besides that particular grounds, I think Mr. Farrer's argument is that if we lose on that, we don't have enough to win. However, I think that you need to complete the hearing on all of our objections, because there are several objections which, if a decision was made to appeal the board's decision to Superior Court, that would make the other objections that are still outstanding relevant. So that I think that to suspend the hearing for now until time certain, or till the board is certified, allows us to complete the hearing, and then if there is further action decided to be taken, you will have a complete record.
I think that as a matter of completeness, I don't think the board, and I know I won't disagree with you. I'm sure the city attorney, because I can hear him in my ear right now, would probably not disagree with you in terms of completeness from a legal standpoint, and I understand it. Even if, hypothetically, if you were not favorable on these 21, the board rules, to accept the registration's verification, as Mr. Tabby calls certification, it doesn't end tonight. I tend to agree with that for the sake of completeness. And all this is going back to the Superior Court anyway, or possibly to the Appeals Court for further proceedings. I'm not suggesting it's fatalistic, or that we're doing nothing here. I think it's good work. One of the things and one of the benefits I'm kind of suggesting here is that it cleans up the voting lists as well. I'm always interested in that, and the board is too. You know, if the signatures are not of registered voters, we'll find out. But possibly, Mr. Farrar is going to march those people and get them registered, dismiss this affidavit, and start again. I don't know. Speculation is everything. But in any direction, we're back here, regardless. The board is asked to consider these to the point at which they are offered. You were put on notice to be here. You're here. I think the board is trying to expend its time as well as it can. And the interjection of an election is burdensome, and it's more than just burdensome. I, in balance, want to make sure that 38,512 voters are properly served. Now, that may not be what you're looking at, and you have your interests. The board is, I've withdrawn my motion, the board is going forward adding 43. Unless the city attorney has another opinion. What do you think? I think it is. I think an argument anyway. We're trying to be expeditious.
Yeah, I mean, the judge orders to do it. These guys, you know.
That's right. I agree. Mr. Newman.
Also, it's a burden on us to move our case along, and we held those in abeyance for a specific reason, so that I think that it would be prudent to just adjourn. You're coming back anyhow, so we can take those up when you reconvene. Thank you.
If I understand you correctly, you don't want to proceed on 43. You'd rather proceed on other matters? You want to start with number 1?
Adjourn until later, because we've probably got a couple more hours if we don't.
I'm not adverse to a couple more hours.
I am.
It's clear they cannot meet their burden under paragraph 43. They don't want to go forward on it. They want more time so they can subpoena people in. But again, I defer to the chair, whatever system that you use to certify, we're satisfied with. I don't think it requires a registration card, is my point. If they were certified as voters of the city, we're satisfied with it. What would they testify to anyway? I mean, they're on a list, and they're on some kind of a list that this city regularly uses and will use, I think on November 3rd, if I'm not mistaken. So I don't see what their appearance does to answer the question why they claim, the mayor claims, there are no registration cards. It's their burden, not my burden, it's their burden, and they can't meet their burden tonight. I think you need to take a vote on 43.
What's that?
What are we doing? I'd like to know.
I think with the chair, I'll let the chair.
It is a public meeting, just want to make sure.
I know, and I think I think the chair is going to address the public.
In the interest of not making a mistake, we're going to adjourn. We're going to continue as soon as possible, given the considerations given by the clerk.
Well,
If I could just interject for 1 second. Rather than adjourn, perhaps
Continue.
we suspend and reconvene.
Right.
That would mean that this meeting wouldn't end, it would be continued to another date, and it might avoid the problems with open meeting law postings. And it maybe under those circumstances, if we suspend and reconvene, we could do it on Monday.
I again would defer to the council president. I know there's probably been some communication to many people to come in on Monday for the ordinance committee into this chamber. Council President?
Councilor Reyes indicated at the Tuesday meeting that the only day that she has available is Monday,
Right.
and that the rest of the week she was not going to be available. So I know there are matters of importance there that we need to follow.
I see them.
I was hoping that probably you guys can continue on Saturday,
A week from Saturday.
and I know that
It's just before the election. It'll be no specific. I'm sorry.
Folks, if we could just maybe, we're doing a lot of whispering in a public meeting.
No, we're trying to work out dates if the public wants me to speak out loud. What the chair was suggesting is a week from Saturday, and I'm sure there'll be a viable date. Again, I run into the same problem. On Saturday, I'll be running around like mad, working on the election of all the things that'll be happening 4 days before the election. Again, I would renew my motion to the board to suspend until after the election is certified. And
I
that's my
second that.
motion. And the motion is seconded. And certainly, I would, as an aside, saying if there's an opportunity to meet any earlier, I certainly welcome it. And I think that is exemplified by the work that's been done here this evening and all along. The motion has been seconded by,
Mr. Chair, may I, as a city council representing a great number of people, it is my opinion that the citizens have been held hostage too long, and that it would be unfair. I know that on both sides, obviously, they want to take advantage. One would like to delay beyond the election. The other one would like to have the advantage of the elections. But it's my opinion as a councilor that the citizens are being held for too long hostage on this matter, which should have been a simple one. I believe that both sides had enough time after the signatures are collected to object and to delay the process for however long they feel like it. But I urge you to please do not hold the citizens hostage anymore.
Mr. President, respectfully, the Board of Registrars did its job. We looked at the affidavits. We issued a petition for recall. We did what we were supposed to do. We're not holding anyone hostage.
No, I understand.
There is a process that is in motion right now that we're going to go through from the beginning to the end, and we're going to do it correctly. Now, that might mean some people are inconvenienced. That might mean some people are pleased and displeased. But we're going to begin, we're going to move through it, and it's going to end. Now, I ask that we do not sensationalize and
Well,
use
I
words like
agree.
hostage.
I agree.
Because no one is being held hostage. We are working on the behalf of the registered voters of the city. And we're doing it in good faith.
And we acted on the court order
Yeah,
immediately.
maybe I used the wrong word.
Thank you.
I apologize for that. People have been waiting already for a long time, and they would like this matter to be resolved. And I understand the city clerk. I know that he has a tremendous responsibility with the elections that are coming. I understand that. And I understand that you guys have a family and you have matters to deal with. And I was hoping that what the city clerk proposed on Saturday probably would have concluded this matter, and then...
And that's not over, and I don't mean to interrupt, Council President. The chair had suggested Saturday, a week from this Saturday. Look, I'll give it a shot. I'll be here. I mean, if I've got to do double duty, and you guys know me, that I will. But the fact of the matter is, if the chair's serious about that proposition,
That's,
yeah, go ahead.
I must tell you, I have tremendous respect for the city council president, tremendous respect. But it is entirely inappropriate for him to come in as a city councilor and suggest to the board how it should run its business. It is entirely up to you. If you want to hold this tomorrow, you tell us, we'll be here tomorrow. But you should not be pressured by anyone, us or anyone else. If it's inconvenient, if it doesn't work, if the process doesn't work right and properly because you're rushed, that is entirely up to you. And now it suggests that there's a motion on the floor that's been seconded, and I ask that you vote on it.
I withdraw the motion, and then I'll motion.
What was
that-
the motion?
The
I'm
motion
sorry.
was to continue this till, to suspend till after the election is certified. So I withdraw my motion, it's my motion, and I'll make a different motion. I motion that we reconvene on Saturday. What day is Saturday? A week from
it's the 31st.
the 30th, oh, Halloween.
Yes.
All right.
I don't think I want to convene on Halloween.
Can you make it? That's really the question.
Say, we aren't being pressured.
And-
I was very clear when I addressed Council
Sure.
President, right, that we aren't going to have our integrity challenged in our own house.
And we also don't want to jeopardize the elections. That's, this is a process and it's important, but that's also very important.
Respectfully, they're equally important,
And that's what I just said.
Equally important. One is not more important than the other.
That's what I just said, that they are
Right,
equally
and I,
important.
it is your process that is under the microscope right now, particularly in an allegation brought by the mayor that something wasn't done right here, so.
Mr. Farrer, respectfully, if there's a problem with the election, there are considerably more consequences than if we delay the recall.
I don't know what the basis is for that, but I'll accept that.
The basis is the testimony of the clerk.
Well, I know if he needs more help, there's no question about it. We know that. Okay. Do the best you can. Thank you.
Shoot for the 31st? Want to do that?
31st.
31st, Adonza?
Sure.
Charles? Can't make it.
I can if I have to, but it's very,
I know. No, we need you, obviously.
If it's not the 31st, we're
Suspend.
going to suspend. Very simple.
I mean, we're running out of days.
well, then we'll do the 31st.
I mean, I don't want, okay. My motion now is to reconvene on the 31st, suspend these proceedings to October 31st, 10 a.m. Is there a second?
Is the city attorney going to be available or not?
Charles?
I'll have to make myself available. I have a conflict.
I'll make myself available
I have
as
a
well.
conflict, but it's,
Okay, I second.
I have a conflict too.
I have a
second.
conflict too.
All in favor? Don't vote no. All in favor, say aye.
Aye.
Aye. All against? Come on, Charles. This measure is continued to October 31st at 10 a.m. These chambers. Mr. Attorney Newman, Attorney Tabbitt, please consult with the city attorney or myself about summonses or subpoenas.
oh, wait,
Hold on. Charles?
we need to set some parameters whereby subpoenas are gonna issue. I mean, it's wonderful that we've, continued this thing for 9 days or whatever it is, but, the last thing, frankly, we need is people coming in on day 7 or day 8 and asking for their summonses or subpoenas or whatever they're looking for.
May I suggest something? This board, it's in 9 days, so it's a week from Saturday? So, this board has our word that by Tuesday of this week, you'll have, this coming week, you'll have presented, if not sooner, but certainly by Tuesday, presented potential subpoenas for the individuals that we are suggesting subpoenaed, created by us, but to be signed, obviously, by the Board of Registrars. and then we have to get them to constables. Does that satisfy you? Is that enough? I mean, I don't know how else to get them sooner to you.
What about Mr. Farrer?
Well, I can't speak for Mr. Farah, but
Nor can I. Mr.
I would-
Farrer can speak for Mr. Farrer.
Who did? You did. Oh, I would, no, my only point would be, anyone who is an affiant need not be subpoenaed. If the affiants appear voluntarily and they want to testify, they need not have a subpoena in order to testify.
So is it your position that you're not going to request any subpoenas?
Nope, no subpoenas. But I will, but I
If you change your
anticipate,
mind,
I'll let you know.
you'll submit by Tuesday?
Yep. But my position would be, anyone who has signed an affidavit need not be subpoenaed. If he wants to come in and testify, he should be permitted to do so without subpoena. They should have a right, as a matter of law, to testify, since they are the affiants.